You're not the stepchild.
All right, Brenna, it is almost 9 o'clock. And it is 9 o'clock. All right, everyone, good morning. Today is Friday, or so they tell me. So everybody should be excited because this is the last day of the work week for some people. And then we're moving into, I think next week, Thanksgiving holidays, right? So we're moving into maybe too much turkey. Don't know. So I'm going to call the docket. When I call the docket, you need to let me know you are here. If you don't respond, I'm going to assume you're not here. And then your Friday may become a Monday because you will be have a warrant maybe issued for your arrest. And the people who sit on the front row are the people who are late. So if you're not late, you may not want to sit on the front row. All right, when I call your name, let me know you're here. Dario Escalante.
Judge, I'm present for it.
All
I
right,
don't see
okay. Angel Rodriguez is in custody. Daniel Rosas, Eric Johnson, Kendra Davis, Jacob Harris, Jose Carvajal.
My case, Judge. He's not, he'll be in about, he said he's here. I think he's walking in the building.
Okay. All right, Tracy Philpatrick will be by Zoom. And the defense counsel will be by Zoom. Damone Wyatt. In custody, we have Santos Serrano, Myron Matthews, Michael Herrera. In custody, we have Nathan Martinez, Angel Rodriguez, Raymond Alejandro. All right, if there is a Julianne Hughes here, your case has been reset for December 13th. Julianne Hughes or Julianne Hughes? Okay. In custody by Zoom will be Julianne Reyes, Jose Ramirez, Danielle Gomez is in custody, John Gonzalez in custody, Sean Branch is in custody, will be by Zoom. Damon Thomas. In custody is Benny Santos, Crystal Cherry, Adam Stacy. Brianna Gutierrez. In custody, Nathan Martinez, Courtney Pride. Johnny Tejeda.
He's present.
Gilbert Alcorta. In custody is Adrian Manriel. Thank you. Manuel Adami. Custody, Jeremy Alvarez, Dwight Basson, Miguel Espinoza, Gloria Orozco, Daniel Maris Medina. In custody is Frederick Condell, Manuel Adami. Daniel Flores. Custody is Myron Matthews, Adriana Harrison. Thank you. Brandon Richardson is in custody. Jody Ochoa. Jody Ochoa. Robert Carter. In custody is Joe Gonzalez. Eleanor Arazola. Thank you. In custody is Noel Balderas, Joseph Berry, David Black, Alex Arazola, Jose Garcia. Jose Garcia. On Zoom is Alejandro Espina. In custody is Jason Hickman, Joshua Carroll. Joshua Carroll.
Still looking.
All right. All right. Is there anyone here whose name was not called? Yes. What is your name? Stand, please. What is your name? I'm sorry, the last name again? All right. Anyone else whose name was not called?
I just walked in with my counsel, Damon Thomas.
All right, Mr. Thomas, thank you. And who's the person with the cap on and the mask? The knit cap sitting right next to Norma Vasquez? Is there a reason you have your cap on? All right, it needs to come off. All right, anyone else whose name was not called? All right, these are the rules of the court. I try to keep the courtroom as least congested as possible. So you'll see files to your right, to my right, which is probably your left. That's criminal trial division. Files on the left for special crimes or SVU or family violence. To my left, probably to your right. Just grab your client's file, place it on the desk. Please take a seat. The prosecutors will proceed with the files that they receive first. Do not approach the court if you have someone who's in custody and you have not spoken to them. You need to have spoken to your client. If an offer has been tendered, you need to give that offer to your client. Then approach the clerk and ask for your file to be placed up here. Have a seat. I will call you in the order of appearance. First will be first and last will be last. We do not skip over. If you have someone who's in custody and you ask for them to be brought out, do not leave because it makes things more complicated. If your client is a Spanish speaker and you ask for the interpreter, do not leave because they're shorthanded with interpreters and that will cause great confusion. Today is Friday. The docket's going to move smoothly. I'm already putting that out in the atmosphere and everybody's going to have patience and you're going to share it with whoever needs it. So everyone, please confirm. Did I see the file on Ospina?
83 in Montreal.
Okay.
Do you have a file?
Judge, I just need to go down to 144. My client didn't show up this morning.
Okay, sure.
2022 CR.
All right, somebody's dimming the lights on me.
Sure, which case?
All right, Mr. Ospina.
Good morning, Judge.
Good morning. Why were you not here in court yesterday?
I never got the Zoom link.
Okay, all right. So have you finished filling out all your PTD information?
Yeah, I got all the documents ready.
All right.
So my client can leave.
All right, your reset date is going to be
Oh, yes.
your next court date is going to be December 16th, okay?
All right.
All right, and it'll be by Zoom.
Okay, thank you so much.
All right, you're welcome. You're excused.
Thank you. Have a good day.
You too.
The good news is you're gonna think of 2020.
Okay. Just give us if we have about it.
How are you? Yes, okay. So I couldn't hear you.
Oh, just give us a minute because we have a lot and we have more images coming up.
Okay.
Hello. Can you
Get the file on Daniel Morris Medina. You need to approach the judge.
All right. Daniel Maris Medina.
Yes, Judge. This is one where about three.
Oh, that's it.
Yeah. Everybody's, yes.
But we-
Everyone, please whisper. Yes,
Pointed at immigration attorney to be able to do a letter.
yes.
Yeah, I'm downstairs.
I was
They have to
waiting
get
for an
on his-
offer,
his house.
but I discussed it more with my client and the immigration attorney also told me she had concerns.
Come back.
Okay.
Yeah. So there should be two motions of competency check about in the file. I don't know if they have been granted or not.
All right. Do you have a motion on the merits? It says one for competency and psych eval.
Well, if it was filed, it would have already been. What's the?
It's 2022 CR 9068.
Thaddeus? Yeah, it looks like, I already has it, my court has it in the system already.
I didn't know if it was granted already.
It said granted from the other case, he has two cases.
Yes.
All right. Do you have a date for it in magistrate court or no?
They did not notify me yet.
Just got here. Not anything has actually yet.
All right. Is your client here?
He's present.
All right. Can you give them a reset date of January 27th and we'll see where we are?
Thank you, Judge.
You're welcome. He has two cases.
We don't have.
See you in 2023.
Yes, I will be sticking around for Joanne Oyos' clients.
Okay. All right. Thank you.
There it is, right?
I'm cool. Those one comment from others, Joy and his others, John. Said January 27th.
Yes.
Thank you very much.
So Reynolds and Gonzalez.
Okay, we back.
Yeah, I just need to ask her a question about this before I turn to my plea paperwork, so. If you need to, please grab her those and I can ask her.
All right. Yes. Mr. White?
Yes, I anticipate he's gonna be a plea today.
I remember.
Before we talk about, the fact that we give him
was
time to
handling
turn himself in, I just wanted to make sure that was still the case.
Yes. So we're pleading today.
If they come back.
That long.
Yeah.
What is he plea for?
What do we do them all separate? right?
And this one, they said they're gonna plea.
Is better send it? Listening to the question. Yeah, he's kind.
Isn't Jody Otero supposed to be in the courtroom?
Went over.
Because I see them on the Zoom link.
180. Oh, that's.
Yeah, I think you just change it.
Yes.
We're gonna have to. That's why I asked him.
Oh, yeah, he's on Zoom.
I don't know. I mean, we didn't mind it. Oh, what? I don't know if that can be like.
Okay,
We have. Very conscious.
all righty. All right, we'll see if his client shows up.
Very.
I'm sorry.
Very conscious.
I thought it was been in San Francisco.
Oh, very.
Yeah.
Very.
Oh,
Conscious?
yeah.
No worries. Making sure
Oh, okay.
you have-
Sanders, can you unmute yourself, please, and show video?
No, but I actually.
All right, what is your name?
My name's Pastor Leona Sanders. I'm representing Jody Ochoa. He's in our ministry at Victory Gospel Chapel, but he'll be on too at the ministry shortly.
All right. So just give me a moment. I'm going to place you in the waiting room. Just give me a moment, okay?
Thank you.
All right, thank you.
Just a minute.
We're gonna need a reset for December the 16th. And then that's the judge, that's the date the judge picked. The judge on Mr. Carroll, I don't know.
Okay.
You
But
remember him? I don't know.
yes, but Damon, we're doing the plea today, right?
Today, right, I'm trying to paperwork in right now.
All right, and then on Carol, I'll call that.
I'm sorry. I love that little guy and I feel terrible about it, but I can't find him.
Okay,
He always makes me laugh. He's such a nice guy. I had him a good deal and
no,
I lost him.
Okay, okay.
Thank you. Yes, this is off document. We're ready.
Jody Ochoa, you need to show your video.
Hold on, that she put this with my plea paperwork, so the judge will already have it.
All right. Jody Ochoa has unstable Wi-Fi. So as soon as he zooms in, I'll put you back in the main room.
I don't know.
That is so weird. I will change that to the 187. That's the strangest thing I've ever seen.
Who's here on Christopher Saxon? Yes.
Your Honor, Michael and I were conferring in the hallway. I wanted to approach very quickly about possibly amending probation condition. When Mr. Saxon was sentenced, the first week of October, the court imposed a 90-day jail sanction as a condition of probation. As you recall, Mr. Saxon's former sheriff's deputy, almost immediately after he got to Bexar County, they realized he was in great danger.
Mhm.
And they removed him from Bexar County and moved him to Kirby. Because of his visible law enforcement tattoos, and for an abundance of concern for his safety, they had to keep him in isolation, which means he's serving 23 hours a day alone in the cell. He served a little over 40 days, that 90-day sanction in isolation.
All right, everyone, please whisper.
In isolation. This is somebody who's never spent any time in jail before. And of course, there's still a continued risk for his safety.
I mean, I understand what you're saying.
My,
I will tell you, there are a lot of people who've never spent any time in jail before,
certainly,
who are in isolation 23 hours.
certainly. My request, Judge, is if the court would consider allowing him to serve the balance of the sanction on full house arrest. If for no other reason than he served the first almost half of the sanction in isolation. And because it's Thanksgiving this week, and I have a mom who's 79, recently widowed, crying on the phone about having to spend Thanksgiving by herself. I think that full house arrest would satisfy any concern of safety to the victim, to community. I think the punitive nature of the sanction has been satisfied because he has had to serve it in isolation. So respectfully, I would just make that request that he could serve the balance on a full house arrest.
Obviously, Judge, we're in opposition. He's in isolation for his own actions. I understand he's law enforcement, obviously proud law enforcement by getting tattoos, but as the court has already stated, there's plenty of people who have been to prison or going to prison who have never been there before, who are serving in isolation. I understand Mr. Slimaine's argument as far as the punitive nature of it, but that would be to suggest that because he's the law enforcement, he is entitled to greater privilege than other people who are convicted and given the same sanction. I feel bad for his mother, but his mother is suffering because of Mr. Saxon's actions against two victims. I think this court was gracious in allowing him to be placed on probation. And so I think that with that, is 90-day jail sanction appropriate? And so we're asking that you just not amend his conditions and let him serve his full 90 days.
All right, if you want to set this for a hearing, we can set it for a hearing and we can bring it back on December 2nd.
Thank you, Judge. I'll talk to the family.
All right, and if you want to set it for December 2nd, and if you want to see if we can have your client by Zoom, then the court will hear your motion.
Okay, very good. Thank you, Judge.
You're welcome.
And I'll just go with the one I'm about to say.
Yes.
Okay, thank you.
And she's out ill today, so you'll probably it'd probably be best to email her. But she just informed her that I've said it. I've announced that a setting can be for December 2nd. But if you speak with the state and they're able to do it sooner and you want it sooner, then we can do it at that time, but not for next week.
I'm not going to be here either.
All right, yeah,
Okay.
I'm giving everybody time off to
I understand.
enjoy their family.
Thank you, Judge. Have a happy Thanksgiving.
All right, thank you. You too. Gobble, gobble. That's what they say, right? I guess the turkey's not having a happy Thanksgiving. Oh, shucks. Do you have another one of these sheets? This one is filled. Okay, thank you. All right, we're going to see if Mr. Choa can zoom in again. All right, Mr. Ochoa, can you unmute, please?
Yes, ma'am.
All right, Mr. Ochoa, so where are you?
I'm in Victory Gospel Chapel in Victory Gospel Church in Corpus Christi.
All right, so your attorney is not here today, so we're going to bring you back on December 2nd.
Is there? Um. Well, yes, ma'am.
All
Yes,
right. Your attorney had a medical emergency, so he's not here. I'm going to recall it for December 2nd. And if your attorney, is your attorney appointed?
Yes, ma'am.
All right. If your attorney is unable to appear, then we'll see about having another attorney for you. Okay.
Yes, ma'am. Thank you very much. God bless you.
All right. Thank you. God bless you too. All right. Ms. Sanders, we'll be back on December 2nd by Zoom.
Thank you, ma'am.
You're welcome.
Thank you. God bless you.
Oh, thank you. God bless you too.
And have a happy Thanksgiving and holiday season. Well, we'll be back on December 2nd, so we have time for that one.
All right. Thank you.
Happy turkey. Enjoy yourself.
All right. And thank you for zooming in.
All right. God bless you.
You too. All right. So that one will be coming back on December 2nd and they'll be by Zoom. No,
Oh,
she's out,
let me write all these down.
She have the blues.
maybe. All hands on deck.
If I may, real quick on Saxon also, I had, he had already filed his, notice of appeal, so I need to submit my withdrawal.
All right. So if you withdraw,
I
then you
know.
can't hear the,
I know, well, I won't hear it. It won't be heard by, with me. It might be heard
Okay.
with somebody else, or depending what he says, we'll see what happens, but I don't want appellate responsibility on this.
okay. No problem. Sure.
Thank you, Judge.
He walks right behind you.
All right.
John Gonzalez. Hello, Mr. Gonzalez, come up. All right, what is happening with this case?
He was asking me if I was fine with
No, stop. Let me stop everybody right there. Nobody come before me and tell me what your plea negotiations are with the state and telling me what the state is offered, because that's not allowed. Everyone knows plea negotiations are confidential. So I don't want to know what the state is offered. I just require that the state tender an offer. So anything else you all want to discuss with me other than that?
I believe that he's not representing me fully. I would like to see if I could get another lawyer. Possible.
Counsel?
Your Honor, we've obtained an offer from the state, which in his situation is a good offer. I've communicated that to him, and his response to what I gave him was he wants another lawyer. That's all the communication
That's been since day one, ma'am. Since day one, we didn't get off on the right foot. I talked to him in the downstairs cafeteria. I believe the phone from the register, and I didn't have a phone at the time, so I called him and tried to set up an appointment. We argued, he argued with me. Said,
All right, so here, this is where we are. This is the attorney that has been appointed to represent you. If you want another attorney, you're more than welcome to hire an attorney if that's what you choose to do. But this attorney has been appointed to represent you. So my understanding is an offer has been tendered.
That's correct.
Counsel, do you have all the discovery?
Yes, ma'am.
State on this case, I'll need an acknowledgement of discovery. It's John Gabriel Gonzalez.
Okay, Judge, I'll do it.
All right, thank you. And I'm going to give you a plea deadline date. Your plea deadline date is going to be December 9th. At that time, you need to let the court know whether or not you're accepting the state's offer. If you choose not to accept the state's offer, then the court will not consider any plea bargain agreements without good cause. Otherwise, you'll have to plea open to the court. Do you understand?
You did.
All right. Is there anything else?
No, ma'am.
All right, thank you. You can take, yes, you can take Mr. Gonzalez back.
Yeah.
Robert Carter. All right, we were
Meet
calling
again.
him, we meet again. All right, could I have a prosecutor? Court is calling 2022 CR 5930, State of Texas versus Robert Carter. Could I have parties announced for the record for the state? For the- All right. This hearing was actually scheduled on November 14th. The defendant was a no-show, so it was recalled for November 16th. Defendant was a no-show. And it was recalled for the 18th for the defendant to appear. This hearing was scheduled at 9 a.m. It is now 9:30 a.m. Deputy, could you call for Robert Carter?
Yes, I did, Your Honor, there was no answer.
All right, defense, have you had any contact with your client? State?
Judge, we'd ask that you forfeit his bond and issue a warrant.
You would ask the bond not to be forfeited, but increased, Your Honor.
All right. I'm gonna forfeit his bond. Remand him without bond. And if you are able to get in contact with your client, the court will reconsider.
Thank you, Your Honor.
You're welcome.
My excuse.
Yes, you're excused. Who's here on Damon Wyatt?
It's the gentleman we spoke of, Judge.
All right, thank you. And there is only one plea, is that correct?
Correct. Yes, Judge.
All right.
Yes, you worked like 2 months ago, so if you could help me.
Oh, most definitely. Okay. Do you need to answer that? Okay. All right, if everyone in the box could please be quiet. Court is calling 2020 CR 6659, State of Texas versus Damone Wyatt. Could I have parties announced for the record for the state?
Brittany Sparks.
Defense?
Charles Bunk.
All right. And are you Mr. Wyatt?
Yes, ma'am.
Counsel, I'm showing you what's entitled discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Wyatt, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand that?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge. And we believe the state has a motion on the indictment.
Just a moment. Caroline. For that one. For this one that we're doing now. Okay, awesome. Ah,
Yeah, we have it.
you are on it. I appreciate it. All right. Counsel, do you waive the reading of the
We
indictment?
do.
State, are you proceeding on the indictment as presented?
Judge, I think we're waiving the enhancement paragraph.
Is that correct?
That is correct, and we do not object.
We don't have everything. No.
All right, Mr. White, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review this document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with felon in possession of a firearm? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
All right, off the record for a moment. Can you read us? All right, Mr. White, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Absolutely.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. White, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen? Court will find that the defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 2 years in the prison. There are no applications. State will take in consideration 2022 CR 6491, 2022 CR 6490, night mag number 6688880, county court cause number 653890. And if you do not show up for sentencing on December 16th, you'll be subject to the full range of punishment, which is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Ma'am.
And did you understand that to be the entirety of your plea bargain agreement? Defense?
Yes, Judge.
State?
Yes, Judge.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Judge.
To the offense is charged, how do you plead? Guilty, not guilty, or no contest?
No, thank you.
State any evidence.
Yes, Judge. States Exhibit 1 and all attachments.
No objections.
Mr. White, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney?
Yes, ma'am.
Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. We'll see you back here on December 16th at 9 a.m.
Yes, ma'am.
It would be excused.
Yes,
Thank you, Judge.
you're welcome. And Mr. Bunk, do you want to answer for Mr. Carroll? Okay.
That's my absentee ballot.
Okay. Could I see the file? Can I see the file on Carol? Joshua Carroll. Oh, thank you. Can I have a prosecutor, please? All right.
Do this.
Court is calling 2019 CR 6812, 2021 CR 1465, 2021 CR 2207, 2021 CR 2771, State of Texas versus Joshua Tremaine Carroll. Can I have parties announced for the record for the state?
Charles
Defense?
Song.
Okay. All right, this case was scheduled for sentencing on November 3rd. And the defendant did not appear, so it was recalled, and it's been recalled several times. It was also recalled on November 14th, then November 16th, and now it's been recalled for November 18th. It is now 9:39 a.m. This here was scheduled at 9 a.m. Deputy, is there a Joshua Carroll?
No, Your Honor, I did announce that.
All right, defense, have you had contact with your client?
I have not, Judge.
State?
We'd ask that you forfeit his bond against your warrant.
All right, that will be granted in each of the cause numbers. As your client makes an appearance, the court will reconsider.
All right, thank you, Judge.
Sure.
May I be excused?
Yes, you may be excused.
May I approach, Your Honor?
Just one moment.
Yes, ma'am.
Yes.
Thank you, ma'am. Put this file up here. Let's see. Is 102CR9969 Gonzalez. Yes, ma'am. Just put it on that, and I'll wait my turn. Yeah.
Who's here on Eleanor Arizola?
Arzola?
So this is not a motion to revoke, correct? This is just for amending a bond condition?
That is
Sorry,
correct. That is correct.
probation conditions. All right, have you conferred with the state?
I have.
All right, the court is calling 2016 CR 5076 State of Texas versus Eleanor Arizola. Could I have parties announced for the record for the state,
Michael Miller, Rapid State.
for the defense?
Derek Amos for Miss Miller, Arzola.
All right, the court is in receipt of a motion to modify conditions of probation. State, have you had a chance to review that motion?
Yes, Your Honor.
Do you have any objections?
No, Your Honor.
All right. If you're drug tested today, what are the results going to be?
Negative.
All right, so we're going to do a drug test. If the drug test is negative, then I will follow the agreement and do a no harmful or injurious contact.
And Judge, if I may, Miss Amanda Garcia is present as well from Judge Burley's court.
Yes.
She's present in the forum. She's actually a caseworker out of Judge Burley's court. She's being tested 3 times a week. It will be for the next year as part of the reunification with her child, which is Joseph is the father of the child. So
Okay.
if you want to speak to her regarding how she's doing there, she's here for the court's discretion.
Okay, awesome. So I'll speak to her after she does her drug test.
Okay.
All right. Adrian Monreal.
Inmate in the back row.
All right, Monreal, if you can come forward. Let's say, have you had a chance to speak with the complainant on this matter?
Yes, Judge. Daniel was handling this case, Judge, and defense counsel just brought it to my attention. There was a disc that we need to have uploaded that was not uploaded, so I'll have it today. It's the data.
It will be surveillance alleging, well, there's allegations, but we would like to view the evidence to see what the video shows. And there may be a restitution figure we're trying to verify. And we're asking only to come back December 1st or December 2nd. We think we should have the video by then. They have the video in their possession.
All right, so we'll recall it on December 3rd. Is that
Let me double,
a good time, or definitely December 2nd is what you need?
I believe the 2nd is a Friday.
Oh, you know what? I'm looking at the month of January. Sorry. All right, so which date did you want?
The 1st or the 2nd.
All right, so let's do the 1st. That's a Thursday.
Thank you, Judge.
All right, you're welcome. Is there anything else?
No, we should have a plea offer at that time.
All right. Deputies, Mr. Monreal can go back. We'll see you back on December 1st.
Thank you, Judge.
You're welcome. Oh, it was reset. Yes. What is his client's name? And I'll give you the date.
Oh, John isn't.
Yes. Okay, let me tell you the date. Okay.
Thank you.
You're welcome. Daniel Flores.
Yes.
Let me find you on the docket. Daniel Flores. Is he on the docket today?
Except for compliance, discovery compliance today, Judge.
Okay.
It's the first one on recall.
See, we always ignore the recall. All right, and you were on time. All right, so where are we on discovery?
Judge, we're still waiting for a buckle and a DNA analysis. I emailed the detective and the sergeant of sex crimes this morning. If I don't hear a response next week, it was a follow-up email we sent about a month ago, then I'll, get some people on the phone or have someone brought over to get this expedited.
Okay. So I have all the school records have been tendered. So those records are, that's from Beatrice Cornelius,
That's the doctor.
because the last time we were here, we needed records from Beatrice Cornelius.
Yeah, Marina's, she's been looking into it. We haven't been able to get in touch with her.
All right, so I'm gonna give you guys another setting date, but if she needs to be subpoenaed to come to court so people can have a conversation with her, then
Okay.
we'll need to subpoena her to come to court. So are you all okay with the date in the new year? Vince, you're okay with that?
Yes.
All right, so I'm gonna set us for January the 6th for discovery. And that should give everybody time to subpoena whomever needs to be subpoenaed.
Is that enough time? Is that enough time for the?
I mean, probably not enough time to get the analysis, but at least like, you know, get the process started.
All right, so they're gonna come back on January 6th, 2023.
Okay.
Who would have thought we would be saying that? All right, they'll give you a reset form and then you're excused. Biddy Santos. Come forward. Hello, Mr. Montgomery. Where are we on this case?
Judge, case was indicted in July. I was appointed in October. I've been on the case about a month and a day, or give or take a day. I talked to the state. They're unprepared to make any kind of settlement offer today. I don't think they're even prepared to decide whether or not to proceed on a enhancement in sentencing. They're trying to get some pen packs and stuff like that. So I can't be ready. I've only been on the case a month. The state, I don't believe, is ready either. And the indictment itself on this first setting case is only, I should never say only, but it's 3 months old.
Okay. All right, let me see what date I will give you. Just one moment. All right, so I'm going to bring you back on January 13th. That's just to see where we are with discovery.
Perfect, Judge. When I heard you saying 6 to somebody else, I was thinking, I hope it's not the 6th.
Oh, why
So
do you
the
have?
13th is just great.
Well, that's Friday the 13th.
I am not a superstitious person, and
You know, people say Friday the 13th is okay. It's Saturday the 14th you have to watch out for. All right, so we'll see you all back on January 13th, and I'll just set that as a discovery so we can make sure that you have all your discovery.
thank you, Your Honor.
All right, thank you. All right, Joe Gonzalez.
Over here, Judge.
All right, the court has signed the request for the CPS records. Is there any other outstanding discovery?
I don't believe so, Your Honor.
All right, were you able to tender an offer today or no?
Yes, Your Honor.
Judge, I just recently got hired on this and we've just been handed some CPS records, so maybe I can jump on that January 13th setting and kind of get my bearings.
All right, I'm gonna give you, actually, I'm gonna give you a plea deadline date, and I'm gonna set this for January 20th.
Okay, Judge. That sounds
So on that time, you need to let the court know whether or not you're accepting the state's plea offer.
all right.
All right, people are dimming the lights.
I'm so sorry, Jay.
All right, your plea deadline date will be January 20th. What that means is after that date, the court will not accept any plea bargain agreements without good cause. Otherwise, you have to plea open to the court. You understand? All right, thank you.
Thank you, Judge.
All right, good seeing you.
Just have a seat, sir.
And Brenna, I'm trying to find him on the docket. Joe Gonzalez.
On the recall also.
Another recall.
I'll just wait to get in line and see the judge on
Matthews.
David Black. Hello.
And it's MTR, we're waiting on the agreement
Okay,
for subject to your approval.
great, thank you. So these are 3 MTRs.
Here they are.
Okay. And is it going to be the same allegation in each motion?
Yes, sir.
All right, the court is calling 2018 CR 6830W, 2018 CR 6798W, and 2018 CR 6799W, State of Texas versus David Earl Black. Could I have parties announced for the record for the state?
Marcus Sanders.
Defense.
Ron Ross, please.
And are you Mr. Black? All right, Mr. Black, in each of these cause numbers, I'm showing you what's entitled motion to enter adjudication of guilt and revoke community supervision. And also First Amendment motion to enter adjudication of guilt and revoke community supervision. Did you review those documents with your attorney? Did you understand them? Are you the same David Earl Black who was placed on deferred adjudication in 2018 CR 6830W for the offense of unauthorized use of a vehicle on July 24th, 2018 for a period of 5 years? And are you the same David Earl Black who was placed on deferred adjudication in 2018 CR 6798W for the offense of evading arrest detention with a vehicle on July 24th, 2018 for a period of 5 years? And are you the same David Earl Black who was placed on deferred adjudication in 2018 CR 6799W for the offense of unauthorized use of a vehicle on July 24th, 2018 for a term of 5 years? Is that you? State, are you proceeding on the same allegation in each motion?
Yes, sir.
Defense, any objection to the state reading one allegation for each motion and then having your client enter a plea to that in each of the motions?
No objection, Judge.
All right, state.
Condition number 2, on or about the 8th day of December 2021. In Bexar County, Texas, the defendant, David Black, did then and there fail to submit to drug testing as directed by the court supervision officer in violation of condition number 2.
How do you plead to that in cause number 2018 CR 6830W? How do you plead to that in 2018 CR 6798W? How do you plead that to that in 2018 CR 6799W? State,
Judge, we'll waive the rest.
any objections to the state's waivers?
No objection.
Did you understand by pleading to violation of condition number 2 in cause number 2018 CR 6830W and 2018 CR 6799W, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? And did you understand by pleading true to violation number 2 in 2018 CR 6798W, the court could find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation to condition number 2 in each of these motions? In each of the motions, the court will find violation of condition number 2 true. Is there an agreement?
There is, Judge.
Yes, Judge, we're asking that you deny the motion in each cause, alternate man to order SATIF. We've agreed to TIC the following cases: County Court 675-883 and Night Mag 641-188.
Is that the agreement?
It is, Judge.
Mr. Black, are you asking the court to follow that agreement? Why have you not been successful in this probation? You need to speak up. I can't hear you.
Had a lot going on. I don't know how to keep saying I didn't work to my drug test and all that stuff. My probation officer told me I was doing good. I don't have to again.
Judge, I would point out, he was successful about 3.5 years on, I believe, on his probation. He did do it for about 3.5 years. He's 22, he's a young guy. Hopefully he's gonna learn. He's got to start not violating the law, and also these did not involve weapons or any kind of violence except for the terroristic threats. Was not a good thing.
All right, Mr. Black, here's something you need to understand. When people say, I don't belong to a gang, I don't do drugs, that's what everybody's not doing. Like, I don't belong in a gang, I don't do drugs. I haven't picked up any new charges. Or at least none that I know of. So I haven't picked up any new charges. So you're gonna have to start doing better. Otherwise, you're gonna find yourself in prison. Do you understand? All right, in each of the cause numbers, the court will follow your agreement partially. The court will deny the motion, alternate amend conditions to include SATIF. What is the wait time for SATIF?
9 weeks, Your Honor.
All right, alternate amend conditions to include SATA. Just 1 second. What is the wait time for ISF cognitive and substantive?
Judge, he completed that back in 2020.
About a month, Your Honor.
Yeah, but did it stick? Did he do ISF cognitive and substantive?
Yes, Your Honor.
So, I mean, maybe he needs to go back for a refresher course. How did you feel about ISF cognitive and substantive?
We didn't really get to do the program that was supposed to be because COVID came, so we didn't have counselors and that.
Oh, so probation, do they have counselors available now?
You should have counselors available, Your Honor.
All right, so they have that now, because it appears to me that he has more going on than just a drug use. What is your drug of choice? And what else? All right. So instead of SATF, we're going to do ISF, cognitive and substantive. And see what is the wait list time for felony drug court. So all alternate amend conditions to include ISF, cognitive and substantive. We can do a referral to felony drug court, but I know they have a wait list, so they won't accept him. I would love to put you in that program because they can really monitor you. Taking consideration County Court cause number 675-883, NIMAC number 64188. And after you're released, the court is going to order full GPS and defer the fees. And after he's been out for a time, then the court will consider partial GPS to start off with. Is there anything else you need from the court to be successful? All right. And probation, if you could, on each of his cause numbers, if you can make sure that field visits are done when he's released, and that's going to be 3 times a month until further notice. And when you're released, are you going to be living with someone? Who will you be living with? Your wife?
Yeah, that's the lady allegedly terroristic threat. She's here today and.
Well, I don't think he should be living with.
They have children.
Yeah, but I don't think he should be living with her.
Well, it was just a, on the phone, and she basically said it was, he mouths off quite a bit. She didn't take it really as a threat. Because he mouths off.
All right, field visits 3 times a month, and you can add parenting classes. I've already had him do parenting classes. You need to complete those parenting classes. And how old are you? All right, so here's the thing. Obviously, this relationship you're in is not working. And obviously, you don't love her the way you say you love her, because if you did, there wouldn't be an issue where you're mouthing off. So what I can tell you is you probably should not be living together because obviously it's not working for either of you. But that case has been dismissed. All right, is there anything else?
That's all.
All right, anything else, State?
No, Your Honor.
All right. Yes.
So if, like, state ISF cognitive substance track and or felony drug court, if they have room.
Yes.
Thank you.
All right, you're welcome. All right, thank you. And State, do you have any dismissals for me?
Working on them.
All right, thank you. All right, who's here on Eleanor? Oh, are you all ready on the UA for her or no?
Negative, Your Honor.
All right, come forward. Where's the attorney for Eleanor?
I don't see Mr. Emmons, but I can text him. Judge.
All right, just have a seat and we'll get in touch with your attorney. Johnny Tejeda? Good morning. What is happening with this case?
Judge, we've, case got re-indicted. And, we just need to set it for a trial date.
This case was re-indicted?
Yes.
Yes, Judge, before the last setting, I believe. This is the second setting since it's been reindicted.
Okay, because I don't have the other file showing the re-indictment. All right, so in each of the cause numbers, do you have all the discovery?
We do, Judge.
All right, State, I'm going to need a discovery acknowledged in each of the cause numbers. Okay. And has an offer been tendered?
Yes. Your Honor. Yes, Judge.
All right, Mr. Tejeda, your plea deadline date is going to be December 16th. After that date, the court will not accept any plea bargain agreements in this case unless there's good cause. Otherwise, you have to plea open to the court. Do you understand?
This one.
All right, they'll give you a reset form for December 16th.
Judge.
Thank you. And on Tejeda, I said 12/16, correct? Mr. Black, your probation is going to need to be extended for 2 years because you're set to expire. All right, and on this case, I don't see where the docket key is on this one. Maybe it got stuck with another one. Or maybe Bashan had it. Oh, okay. All right, we're going to go back on the record in 2016 CR 5076, Eleanor Arazola. Now parties come forward. All right, I've been informed that her UA was negative. You said that there was someone here from CPS court.
Yes, yes.
All right, if you want to call her as a witness. All right, if you could state your name for the record, please.
Amanda Garcia.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, defense.
Mr. Chair, how do you know Miss Arazola?
I am currently her court monitor assigned the early childhood court.
And how often you see Miss Arazola in the early childhood development court?
I see her at least once a week.
Do you know how often she's giving UAs to that court?
She gives 3 UAs every week.
Okay. And so far, those UAs all been negative?
They've all been negative.
Okay. Do you know how much longer you'll be monitoring or being her caseworker for?
It will be a little bit after the length of the CPS case, so approximately 13 months.
13 more months. And the no contact that were in front of the court about regards Joseph Miranda, correct?
Correct.
And he's the father of Eleanor's 6-month-old son.
Correct.
Okay. And we're trying to get the no contact order lifted so they can possibly have reunification as a family with the child. But right now, the child is with Joseph's parents, correct?
I believe it's a cousin.
Cousin. Okay. But that's sort of the reason why we're getting the no contact order lifted so they can communicate regarding the well-being of the child, perhaps reunify at some point down the road if that's what they choose to do.
Yes.
Is there anything that you think would be important for the court to know regarding the work you've done with Ms. Arazola regarding how she's doing there, or do you think anything, court needs to know anything further?
Sure. So far, she's in full compliance with our program, as is Mr. Miranda. In addition to the drug testing, she's doing substance abuse treatment through probation, but we will be referring her to an outpatient, so she'll have basically those services the entirety of the case. We also do psychiatric care, individual counseling, and a really in-depth parenting class that involves both parents with the child, like in their home, or any other services that come up, financial planning, anything really to help the family be more secure in the case of post.
Thank you very much.
All right, has services in the form of counseling taken place between her and Mr. Miranda as a
They
family
haven't
unit?
yet, but if the no contact order is lifted, we will do couples counseling for both of them together.
All right, and how long is couples counseling?
It usually is like during the length of the case, probably the last 4 months of the case, they'll do individual and couples.
All right, state any questions? State?
Oh, Judge, no questions.
All right. All right,
I'm
thank
so
you.
sorry.
Thank you for coming down.
Thanks, Mr. President.
All right, anything else, defense?
No, Your Honor, we just asked the court consider removing the condition that Judge Glenn imposed, the no contact order, Mr. Miranda, remove that and make it a, I suppose a no harm or interest contact, but there's no victims between them. I think they're more users together was the issue, Judge, back then. So we're asking the court to consider removing that as a condition of
All
probation.
right, we'll do no harm for interest contact, and I consider people who are using together that's harmful. So both parties are aware. So, all right. Well, it's good that you're doing well on probation and doing well with CPS. You know the consequences if you don't continue to do well, correct?
I do.
All right, thank you. I'll alter the main conditions to include no harm for injurious contact.
Thank you, Judge.
Thank you. You're welcome.
Maybe excuse.
Yes, and probation, could you make sure that you stay in contact with the CPS worker? All right, thank you. Who's here? Michael Herrera.
Good morning, Your Honor.
Good morning. All right, what is where's right. Oh, Michael Sawyer. You and your brother. Hi, this is not the one I was talking about, though. Good morning. All right, have a good one.
I'll be back.
All right. So what is happening with this case?
Judge, we're almost done with discovery. The state did get in a third CAC video. I do need to review that. And they have an outstanding subpoena for some school counseling records that are not in yet. So I just asked for another setting for discovery.
So school records and what else?
I just need to review the third video. That was one that they had to request. It wasn't initially available.
All right, state, when do you expect to have this outstanding school record? On Mr. Michael Herrera.
Judge, we requested them a while back. We can follow up. I don't know if the holidays are gonna delay trying to get it. You know, I would hope we'd be able to get it, you know, before mid-January.
Okay. All right, I'm gonna give you all till January 12th. And you'll receive a reset form.
Thank you, Judge.
You're welcome. And that is on Michael Herrera.
Thank you.
Myra Matthews. All right, so the last date that was here, which is from Judge Herr, was in regards to his psychological evaluation.
That's correct. It's been completed and returned, Your Honor.
All right, and what are the results? Do we have that yet?
Confident, Your Honor.
All right, and have you received all the discovery?
We received most of the discovery. That was not my issue. I filed a motion with the court. I don't know if the court had time to look it over.
It's a motion to withdraw.
Or a continuance. All depends what the court's ruling is and what Mr. Matthews would like me to do today.
Well, what I was gonna do, oh, I have it in here. Yes, I can hear that. What I usually do is I see if all discovery has been submitted, and if all discovery has been submitted and an offer has been tendered, then I give parties a plea deadline date. So,
My main concern was I'd had significantly less conversation with my client I would like the last month and a half.
okay,
Is explained in the motion. I explained to Mr. Matthews. I take on a case like any law, they're obligated to give a certain level of representation. Right now, I'm simply just not there. I've explained it to Mr. Matthews. I explained it to the court, give me about 60 additional days. I'll be ready for trial or whatever it's going to take.
well, your plea deadline date would be a date that's in January. Then after that date, if Mr. Matthews decides not to accept the plea, then you will be given a jury trial date.
That would work. That would give me adequate time to finish everything that I need to do in this case. And I'd like to ask Mr. Matthews on the record, Mr. Matthews.
Oh, well, let's go on the record.
Okay.
Court is calling 2021 CR 9850, State of Texas versus Myra Matthews. Can I have parties announced for the record for the state,
Michael Villarreal for the state.
for the defense?
Michael J. Sawyer.
All right, so Mr. Sawyer, my understanding, you've received all the discovery,
Yes, I have, Your Honor.
and has the state tendered an offer?
Yes, I have, Your Honor.
All right, the court would set the plea deadline date at January 12th,
That'd be good. Thank you, Judge.
and then your jury trial date would come after that, Mr. Matthews. If you decide not to accept the plea on that date, then the court will not consider any plea bargain agreements without good cause. Otherwise, you have to plea open to the court. Do you understand? All right, and there's something you wish to put on the record?
Yes, Judge. Mr. Matthews, you know, on your behalf, I filed a motion to withdraw as your attorney in this case. Not that you and I don't get along, but I cited to the court various things going on in my life, personally to my wife and her health, some medical problems right now. Could slow down my ability to see you and counsel with in the recent months. You're aware of that. I explained that things now are back up
on par getting home with my wife. And I can give your case down the full attention it's going to need. But the decision as to keep me on or ask the judge for a new trial, that comes from you, correct, sir? Will you just tell the judge today, what is it you'd like me to do as your attorney?
I can continue on.
I'm sorry,
I'd like to continue.
with Mr. Sawyer as your attorney?
Please.
All right, so Mr. Sawyer, are you withdrawing your motion? to
I'll
withdraw?
withdraw that motion, Your Honor. But I thought morally I had to file that with the court.
All right, thank you, Mr. Sawyer. So your plea deadline date is going to be January 12th, 2023. On that date, you'll need to let the court, everyone, there's no talking in the box while the court is on the record. So your plea deadline date is going to be January 12th, 2023. At that time, you need to let the court know whether or not you're accepting the state's offer. If you decide not to accept the state's offer on that date, then your plea deadline date would have expired and the court will only accept pleas open to the court. Otherwise, you have to, or either with good cause. Do you understand?
Your Honor.
All right, and Mr. Sawyer, if you want his case brought back sooner than that, you can always let the court know.
Thank you, Your Honor.
All right, thank
And I
you.
appreciate the court's time and courtesy in this matter.
All right, you're welcome. Have a good one.
Very
I
much.
hope everything's going well with your wife.
It just got a lot better, thank you.
Oh, that's awesome. Who's here on Gloria Rosca? And where's your client? Let me find her on the docket. All right, so the state was going to provide you information on PTD, is that correct?
That's correct.
Has that been done?
It has. We've accepted their offer. As a matter of fact, this morning, Ms. Brooke and I sat down and we completed the application on the form. I've sent her the information that she needs for the supplemental documents. She's gonna try and get that to me ASAP so we can get that application submitted.
All right, so we're going to come back on December 16th to see where we are with that.
Perfect, Judge.
All right, and you'll receive a reset form.
Thank you, Your Honor.
You're welcome.
See you on the 16th.
It'll be at 9 o'clock.
Yes, ma'am. Right.
Oh, they need to give her a reset form.
We're gonna give her a form.
Gilbert Alcoria. Brenda, they tell me I only need my glasses for distance, and when I get tired of pulling them off, then I'll get the line. I'm not tired of pulling them off, obviously. All right, so my understanding, my last notes, there was a plea that was to be entered, and this was October 26th.
Nope. It
It
was
says offer tender, October 26th, defendant will be late for court, plea to be entered. And so I don't know if he was entering a plea in misdemeanor, but what's going on with your client?
Okay, number one, an offer has been extended, and the offer is that they want my client.
Oh, no, I don't want to know about the,
Okay.
so what's,
A precondition to this offer is determinant on the misdemeanor court, which there has been no file and has been reset to December 29th. And then I just got another email that now is set for January 6th. There has no file. It is not a.
all right, what is the misdemeanor case?
DWI.
All right, state on criminal trial division. I'm being told that there is no misdemeanor file for Mr. Alcorta to enter his plea. Is there anything that you all can do to facilitate that? That's in County Court 8, so they're putting his court date in January.
Yes,
Okay, good.
I'll work on it today and we'll get it filed on by Monday.
If I can inform everyone.
Mhm.
It is, the results came back with no alcohol, so it got resubmitted for a drug analysis. And that is the reason there is no file. That is the reason that it has not been able to even be entertained.
All right, state.
If I can confer with. defense counsel.
Okay, all right. All right, just have a seat. They're gonna confer. Dario Escalante.
Morning, Your Honor, Robert Featherston representing Mr. Escalante.
All right. Court is calling 2022. Yeah, your client is correct. Court is calling 2022 CR 6753 State of Texas versus Dario Escalante. Can I have parties announced for the record for the state, for the defense?
Robert Featherston representing Mr. Escalante.
All right, Mr. Escalante, you entered a plea of guilty to count 2 on November 7th. This was recalled today for sentencing. The state waived count 1 and the enhancement paragraph. Are you ready to proceed with sentencing, defense?
We're ready to proceed.
State, you're ready to proceed?
Yes, Your Honor.
All right, the court will follow your agreement, find you guilty, sentence you to 2 years in the prison, give you credit for any time served. Is there anything else with regards to sentencing?
No, Your Honors. Mr. Escalante has some property still in the possession of China Grove. I will file a motion with the court, though, to have that released to his sister.
All right, thank you. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Ma'am, can I ask you a question?
Yes.
I tried to, retrieve the property that I had, from, China Grove, and they said they needed an order of a release form or something. I came down here yesterday and, I couldn't get any help with that, and
Your attorney helped file a motion. And your attorney said that he would follow.
Judge, I already have the motion. I just need to change the particulars now to have his sister pick it instead of himself.
just want to make sure.
All right, sure.
Thank you, Mr.
Yes.
And I'll
And
have that
just,
file later today.
all right, and just confer with the state over whatever property it is.
Thank you.
You're welcome.
Thank you, ma'am.
You're welcome.
Your Honor, if I may, can I have my brother?
No. All right, the court is calling 2021 CR 5266 State of Texas versus Jacob Harris.
Thanks, Marcus.
Who's the attorney on Jacob Harris? All right, if we're gonna have parties approach, Mr. Harris, come forward. Have parties announced for the record for the state,
Brittany Sparks.
defense,
Good morning, Judge Ted Wood for Mr. Harris.
and are you Mr. Harris?
Yes, ma'am.
Showing you what's entitled motion to enter adjudication of guilt and revoke community supervision and First Amendment motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it? Are you the same Jacob M. Harris who was placed on deferred adjudication in 2021 CR 5266 for the offense of evading arrest detention with a vehicle on April 14th, 2022 for a period of 2 years? Is that you? State?
Yes, Judge, violated condition number 4 in Bexar County, Texas. The defendant, Jacob M. Harris, did then and there fail to report to the supervision officer as directed for the months of May, June, and July of 2022 in violation of condition number 4.
How do you plead to that? True or not true?
True.
We'll waive all other violations.
Any objection?
None, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. Is there an agreement?
Yes, Judge, we're asking that you deny the MTR and alter and amend for a TAP. We would request this be done in custody and then to follow all of the treatment recommendations as well as weekly reporting for 60 days.
Is that the agreement?
Judge,
for the most part, I'm asking that Mr. Harris be released to the Haven for Hope, and that he be allowed to make an appointment to do the TAP evaluation with the Community Supervision Department while he's living at the Haven for Hope.
All right, that'll be denied. All right, Mr. Harris, do you not have a place to live?
Yeah, but it's in Copper's Cove.
All right, why are you whispering?
I said it's in Copper's Cove.
All right, and where's Copper's Cove?
It's in Texas.
So by Colleen Judge.
All right, so who's in Copper's Cove?
My lady,
I'm sorry, who?
my lady,
Your lady, what is your lady's name?
Rosh,
I'm sorry, what?
Rosh,
Rasha? How do you spell that?
RASHAA. Last name Kendrick.
Does she want you there?
Yeah,
That's either yes or no.
yes,
And does she know you have drug problems?
yes.
And does she have any children?
No, man.
Do you have any children?
Yes.
And what are their ages?
Right on 3 in January. My son, he'll be 2 in July.
And are you employed or have you been employed?
Yes. I was
Where-
working on house.
I'm sorry,
I was working on house
and where are your children?
in St. Louis.
All right, when's the last time you saw them?
Probably about 8 months.
If you're gonna have children, you need to support them and be in their life. If you're a good role model. All right, this is what the court is gonna do. The court will deny the motion to alternate amend conditions to include TAP while in custody. He's to follow all recommendations of the TAP evaluation. I'm gonna want weekly reporting upon release for 60 days. We're gonna do the UA hotline for 90 days. Field visits 2 times per month. And probation, you can have those field visits coincide with the reporting. And do you want your probation transferred to Copper's Cove?
Yes.
All right, and we'll see about transfer to Copper's Cove, but he's not to be transferred until the TAP evaluation. And if the TAP evaluation recommends inpatient treatment, he's going into inpatient treatment. And then he could see about the transfer to Copper's Cove at that point.
Judge, will the court also consider outpatient treatment?
No. All right, and they're gonna have to see if there's anything out in Copper's Cove for your probation to be transferred. If they're unable to transfer it there, and if Copper's Cove doesn't accept you, then you'll be in Bear County. Is there anything else?
Nothing.
All right, probation, is there anything else that's needed?
Your Honor, if Copper's Cove is a county that we service, is it okay for him to, and the transfer, doesn't go through, or, since it's something that we service, is it okay for him for virtual office visits?
There's gonna need to be somebody to do some field visits. Will that still be accomplished?
No, not if he's still here, not if he's here. So we'll check.
All right, thank you.
Copper's Cove's pretty it's got a pretty big population, there, Judge. It's right close to Fort Hood.
Oh,
So there should be some services out there.
okay. All right, thank you.
Thank you, Judge. May I be excused, Judge?
Yes, you may be excused. All right, are the parties here on Gilbert or Corta? Has that been resolved?
We're still working on it.
All right, thank you. Just let me know when you're ready. Okay, all right, thank you. Alex Arizola. All right, come forward. All right. All right, your case is going to be recalled. Your attorney is not here. So it is going to be recalled for December 5th. They're going to give you a reset form.
They want me to go to work. Appreciate it. Thank you. Y'all have a happy Thanksgiving.
All right, thank you, you too. Who's here on Crystal Cherry?
Morning, Judge, for present.
Good morning. All right, state on this case, were you able to contact the complainant?
We were, Judge. We're asking for a little more time. There is a witness that we need to speak to. That may affect how we proceed with the case. Additionally, I asked the defense counsel to look into seeing if mental health could be as well. So he's gonna do that also.
All right, so how much time are you guys requesting?
A couple of weeks.
All right. So I'll put you all, is December 13th enough time?
It is.
That's fine, Judge.
All right, so Ms. Chair, we're gonna come back on December 13th, okay?
Yes, ma'am.
Everyone's trying to work to resolve this matter.
Yes, ma'am.
All right, thank you both.
Judge.
Ms. Sherry?
Yes,
Porter,
yes.
state will be, we've got an agreement. They're gonna create that file and we'll publish it.
All right. So Mr. Alcorta, if you can come forward. All right, so what date do you all want this to come back on?
So we'll have the file created by early next week. I guess it just depends on how quickly you think we'll unplay to issue them.
Yeah, if we can give us the same December 16th date for your court,
Okay.
and then I'll go county court date to line them up.
All right, this is Gilbert Alcorta. And we'll do December 16th. Okay, and you'll get a reset form.
Thank you.
You're welcome.
That is, no.
But did you say, do you see what Mr. Alforte is?
During the bad years and the years that actually worked out.
Page 14.
All right, thank you.
Your papers,
Yeah, I'm done.
have a sentencing ready on Angel Rodriguez.
Mr. Garcia, I can't even. Yesterday, I texted him this morning, I was like, dude, I can't even access almost all of them. He's gonna do it all anyway. James and I used to work at the DA's office together. He's a megalomaniac, like he holds on to everything. So I'll just sit there and take a nap.
16?
And that one, it was just.
Yes. So we said 16th and not the 6th. Because that's Damone Thomas as well, right?
Yeah.
It's her 16th. Okay, all right, thank you. All right, Jose Garcia. Yes. All right, is this Mr. Garcia?
Yes, ma'am.
All right, so where's his medical documentation?
Your Honor, they didn't release him last night, so he just left. He didn't have any documentation. I told him to be here without fail, and he didn't know what else to do, so he just left. I can go get the records, but that's where we are.
All right, what are we doing with his case?
We didn't look at the case because we weren't here yesterday. I'll visit with the DA this morning, but most importantly was I wanted him here.
All right. So on this case, we're going to recall it for Mr. Stohansky. You need to stay and confer with the state.
Yes, ma'am.
But we're going to recall this back on December 9th. And you need to be here and you need to be on time.
Yes, ma'am.
And if there is a medical issue, you had better bring the court medical documentation. You understand?
Yes, ma'am.
All right,
Thank you, Judge.
you'll get a reset form for December 9th. And he has 2 pages.
Thank you.
And this is.
Big Thanksgiving.
Angel Rodriguez. Who's the attorney on Angel Rodriguez?
I represent all Angel, Judge.
Okay.
And Jesus is.
That's me.
All right, court is going to call 2022 CR 4503, State of Texas versus Angel Rodriguez. Could I have the parties announced for the record for the state?
Catherine Pollard.
Defense.
Monica Guerrero for Mr. Rodriguez, Your Honor.
And are you Angel Rodriguez?
Yes.
All right, you entered a plea of no contest on October 4th. This was set for a PSI hearing on November 9th, but we're here back on November 18th. According to the plea bargain agreement, punishments be assessed at a cap of 10 years. There's a $1,500 fine. The state is opposing your application. There's an affirmative finding of family violence, no contact with Mallory, Mallorie Salazar. They're taking in consideration 2022 CR 1177 and grand jury number 779652.
Judge, for the record, that grand jury number has been indicted as
Yes.
well.
And I believe that then the corresponding number with that is 2022 CR 9837. Is that correct?
Yes, Judge.
All right. Have both parties had a chance to review the PSI report? State?
Yes, Judge.
Defense?
Yes, Your Honor.
Any objections to the PSI report?
No, Your Honor. No, Judge.
All right, State, do you have any witnesses?
No.
Defense, any witnesses?
I have his family, but I can proffer to you what they're doing today.
All right, you may make your proffer if there's no objection.
No objection. Judge, they want to come up here and tell you that although Angel looks like he's not been on the right path, that they're here to support him. He has a job that's waiting for him. His father works in HVAC and they have a job there in case the other job, if flooring does not work out. His mom says that she is going to implement other procedures in the house, and his brother as well have indicated to me that he will be supervising him carefully. He has no contact with any of the people that are involved in these cases, and he would really like for them to have a chance at probation.
All right, does anybody want to address the issue where on page 4, number 8?
I don't have a PSI. Page 4, number 8. I have one moment to
Yes.
verify it. Your Honor, my approach.
Yes.
My client's father is willing to come and testify that he never, or no one in the family called her to say, to sign an affidavit or to lie.
Okay, I mean, does anybody want that issue addressed?
Judge, I was just gonna argue what's in the PSI.
I mean, if you want to call them as a witness to say that, otherwise I'll take your proffer that that's what they would say.
Then I'd like to call him.
All right.
May I call Angel Rodriguez?
Yes.
Sir. I'll wait to the front. Sir,
Good morning. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Angel Rodriguez,
All right, defense.
And how are you related to Angel Rodriguez, the defendant in this case?
that's my son.
There's some indication in here from a lady named Mallory Salazar that you or your family members contacted her in an attempt to get her to lie on an affidavit. Is that true?
No, ma'am, no, we have not had any contact with her in 3-4 years whatsoever.
And are you asking this judge to place your son on probation?
Yes, ma'am.
Why?
He has been doing better for himself, and I think he deserves another chance to better himself out. He had already been doing, he's been staying away from these, or her, I should say, and he has a job waiting for him with me. He gets the opportunity to do so.
What type of job do you have?
I do HVAC for a living.
And how are you gonna make sure that he doesn't go around any of these people and cause more trouble?
He's gonna be staying with me, living with me, working with me, 24/7. I'm gonna be like a hawk on him.
And can you guarantee that you will make sure that he stays away from any type of drugs or alcohol?
Yes, I will.
And how
Make
do you
sure
guarantee, how do you guarantee that?
Like I said, just by staying on him, keeping with, keeping me 24/7. The only way I can do it. And I think on his own, he's gonna be able to do it as well, but I won't let that happen until I'm for sure he's ready to be on his own.
Why else do you think that he would be given a chance?
He's young, still got life ahead of him. I think he needs to figure out what he wants, and he won't be able to drink behind bars.
I'll pass the witness, Your Honor.
State, any questions?
Just a few questions. Are you aware that Ms. Salazar has repeatedly said she wants nothing to do with your son?
Am I aware of that?
Mhm. Okay, are you aware that she wants nothing to do with your family?
No, I'm not aware of that.
Okay, are you aware of any reason that she would make up you contacting her when she wants nothing to do with any of you?
No.
Okay. I don't have any other questions.
All right, so I have a question. So who is the person who contacted the complainant and asked her to write an affidavit?
I have no idea of that, Your Honor. Honestly, I don't want to contact my son's ex or girlfriends that I have.
Well, what about other family members? Did someone else in the family contact her, or could have contacted her?
That I know of, nothing. I really don't talk to the mother of Angel, so, or their side of the family as much, so I don't know anything of that. It's my end, as far as my sister, brother, nobody contacts her or even has her information to contact her at all.
All right, any other questions
No,
on
Your
either
Honor.
side?
No,
State-
Judge.
All right, thank you.
Thank you, Your Honor.
You're welcome. All right, the court, if there are no further witnesses, the court will hear argument. All right, any other witnesses?
Oh, no, Your Honor.
All right, state.
Judge, on this case, it's really just based off of what you have in State's Exhibit 1, the facts of the case, the nature of the case is being taken into consideration, defendant's criminal history, and also the fact that the family that is supposed to be, and he would supposedly be going back to and being kind of overseeing to make sure that he's headed in the right direction is the same family that is asking the complainant to lie in this case. Based on the facts, based on the history, and again, those cases that are being taken into consideration, we ask that you deny his application for any community supervision.
All right, defense.
On behalf of my client, that she is young, and his father is correct that he does have a lot of life ahead of him, and to go ahead and send him to prison at this time seems to be a rush. If the court would decide not to give him probation, but instead to give him deferred, he would have a huge hammer over him if he decided to drink again or use any type of marijuana or even go around any of the women. At this time, Judge, we are asking that he be placed on deferred only so that the court can have an additional amount of time to incarcerate him if he decides to step off the path that his family has created for him. Now that they know that he has these issues, his father has assured me that he's going to keep on him 24/7 and that he's going to be working with him. He will have no free time to do anything except do what his dad tells him.
Anything you wish to say, Mr. Rodriguez?
I mean, just like they were saying that I'm young and I see you give a lot of other men.
No, don't do that. Here's the thing. Do not compare yourself to other people, because I tell everybody in this court that everybody is an individual.
Okay. Well,
And I will tell you what I see with you is this case that you pled to is a burglary of a habitation. Then you have a injury to a child case that's being taken consideration. Then you have another burglary of a habitation. So, and these offense dates are June 11, 2022, September 21st, 2020, October 8th, 2020. Those are concerns. So is there anything else you wish to say?
Well, me saying that what I was intending to say is that I see that you're pretty fair. And, you know, I hear of like second chances and all that, and I feel as if I should at least get one chance just to show. And if you see me in the courtroom again, then you could do what you want to do. I'm asking for probation for one chance to show that I'm trying to better myself.
One moment. All right, can I have parties approach? Can you place them? All right, this is what the court will do. Court will find you guilty. Deny your applications. There's an affirmative finding of family violence. There's to be no contact with Mallory Salazar. There's a $1,500 fine, time and money to run concurrent. Take in consideration 2022 CR 1177 and 2022 CR 9837. Sentence you to 6 years in the prison. The court will retain jurisdiction, showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction and an affirmative finding of deadly weapon, you're not allowed to own or possess any weapons or ammunition.
Your Honor, for the record, there was no affirmative finding of a deadly weapon.
Oh, I'm sorry, affirmative finding of family violence. Thank you. Because this is an affirmative finding of family violence and a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, and while you are at the prison, you had better show the court something. You understand? And your attorney will explain that to you. Is there anything else from either side?
Yes, from me.
Nothing from me.
All right.
Because I'm appointed in this case and the court is retaining jurisdiction for me to be able to file a motion for stop probation, is the court ordering me to stay on the case until we get to that point where I can file some motion to reconsider at that time?
Yes.
Thank you.
All right, is there anything else? All right, thank you.
Sir Rodriguez. I need to talk to, okay, well, I can talk to him up here.
Courtney Pride. Good morning. All right, Ms. Pride, why were you late for court again?
I have car trouble this morning, I apologize, and I have a little one that I have on my own, so I had to get her to school. Without my car.
All right, so here's the thing, you cannot be late again. You understand? This will be, if you're late again, that will be the third time that you're coming in late. And the court requires everyone to be on time. All right, the state was supposed to contact the complainant in this case.
Yes, Judge, we are still working on it. It's one where Daniel spoke to the complainant wanted some time to think about the different things that we discussed. And Daniel was gonna call him back this week, but wasn't able to.
Okay. All right, so we're gonna bring this back on December 9th. All right, Ms. Burt, all right, Caroline will give you a reset form. Oh, here it is. It's pride. Nathan Martinez. Morning. All right, so the last time we were here, I guess it was a felony drug court screening or something.
So apparently the screening didn't happen, so Bianca was Sean was kind enough to start the process this morning. So
Right, so where are we going with these cases? Because based upon the nature of these cases, is there some thing that is happening that the court is unclear on?
the prosecutors are being meanies. That's what it boils down to. No, Judge, there are some issues, well, from our perspective, some issues with some of the cases. And what I was going to request is that these be placed on a trial docket at some point, but obviously, from my perspective, hopefully by the next setting, we should have the drug court evaluation to determine whether or not he qualifies for it. But we would like some pressure put on the prosecution in terms of the trial setting for sure.
So let me ask you this, do you have all the discovery in all of
I
these
do.
cases?
I think
Has an offer been tendered?
it has, and it's been rejected.
All right, so I am going to set this for a plea deadline date on December 19th. And after that, if you decide not to accept the state's
I will
offer,
not be in town on the 19th. I'll be in McAllen. I'll be back that next day.
all right, how about the 16th?
Sure.
All right, so we'll bring this back on December, wait a minute, I'm sorry, 16th is not a good day because we already have the 15th. So December 15th.
Sure.
All right, so on December 15th, you'll need to let the court know whether or not you're accepting the state's offer. If you choose not to accept the state's offer, the court will not consider any plea bargain agreements without good cause. Otherwise, you have to plead open to the court. Do you understand? Thank you.
Thank you, Judge.
You're welcome. And state, if you can get the discovery acknowledgements signed. Yes. Yes. All right, thank you.
May I be excused, Judge?
Yes.
That's good.
All right, who is here on Susan Hernandez? That's off docket.
And Your Honor, Suzanne Hernandez, I just got hired yesterday. She just got booked into Bear County Jail yesterday.
Yeah.
It's a deferred adjudication. I'm requesting a bond set. And you have known me for a very long time. You know, I work very closely with my clients and my clients don't tend to disappear. She also has an infant, less than a year old. I have medical proof of that. If the court would like to see, and we're simply asking the court to set a bond. So that we can start working toward a resolution.
All right, I've conferred with the state.
I have spoken with Mr. Sanders. I have given him a copy of the motion. It's a possession with intent case. The state had no objection to setting bond.
Yes, I need to know what her criminal history is. I'm gonna need to know whether or not she's ever missed court. What we can do is I can send it to, magistrate's court.
Your Honor, she has an infant, 11 months old.
Magistrate's court will do it today.
They will hear it today.
Yes.
Okay. Then I will wait and I'll walk it myself.
All right.
Thank you.
Mhm.
Your Honor, I'm told I had an issue in magistrate's court yesterday, and I have reason to believe, and I do believe the magistrate's court is not open today. If it is not open, will you allow me to come back? Because I had an issue on their docket yesterday.
I cannot hear that case without the information that I requested as far as setting a bond. But magistrate's court, they're open 24/7.
That's fine. We already know that she did miss a court date. I have documented that in my motion. If we can get a criminal history from the state, is there anything else that you needed?
You'll need to take it to the magistrate's court. They will do it, or either you can take it to Judge Carruthers.
I think you're on.
All right, you're welcome.
Did you want me to walk it back to a little bit? Okay. Thank you.
Mr. Reyes, we're just waiting on your attorney. So I'm going to mute you. And then as soon as we're ready to proceed, I'll call you up. Yes.
Yes, mute.
Okay.
Sorry.
Okay, yeah.
Right over there. Straight ahead.
Approaching this. You want me to approach?
Yes.
I filed this, I'm asking for an investigator, second degree repeater. Please. How are you?
All right.
Thank you.
You're welcome.
Appreciate you.
It's my word, it's her vehicle.
Tracy, stop unmuting yourself. If you continue to unmute yourself, what will end up happening is you will be sent back without seeing your attorney. I've told everyone on the Zoom that as soon as your attorney is present, we will hear your case. So you have one more time to do that.
Yeah, I'm going to go grab this. Which one?
State, Bob Behrens is supposed to be zooming in, but he has two cases on the docket. One is family violence, one is criminal trial division. Could you all call him to confer off camera before he zooms in? Great, thank you.
This gentleman here.
Yes. Oh, that's
I didn't
okay.
have it on my calendar.
No problem. But it is Mr. Daniel Rosas.
See you in custody.
Yes.
Yes, I just requested him to bring
Yes.
them up right now.
Makes you happy.
Bring them up.
Can I see the files on Tracy and Branch, please? All right, can you meet us? All right, Mr. Tracy and Mr. Branch.
Yes, ma'am.
Yes, your attorney's had an emergency, so we're gonna bring you, he's had a family emergency, so we're gonna bring you back on December 2nd. But on that date, we'll actually have you in court, and it's probably easier to confer in court with your attorney than it is by Zoom. So we'll be back on December 2nd, okay?
Yes, ma'am.
All right, thank you. And so
Thank you, ma'am.
that's 14D and 14A. All right, Mr. Branch, don't leave until a deputy removes you, but we're going to call them and let them know you can go back.
Yes, ma'am. Thank you, ma'am.
All right, thank you. Thank you for your patience.
Yes, ma'am.
State on Branch and Tracy, that's going to be recalled for December 2nd. All right, who is the party on Joseph Berry? The attorney for Joseph Berry. Oh, it's David.
I'm sorry, Judge.
All right, you ready on Joseph Berry?
I am, Judge.
Okay.
Fair.
Court is calling 2022 CR 10033, State of Texas versus David Berry. Can I have parties announced for the record for the state?
Brittany Sparks.
Defense?
David McLean for the defense.
And are you,
Mr. Correct record is Joseph Berry.
oh, it's Joseph Berry?
Joseph
Why did I say David Berry?
Pride me.
Oh, David McLean, right? Yeah. Okay, we're not going to blame it on my vision. Because I'm holding on to this prescription as long as I can. All right, Joseph Berry. Are you Joseph Berry?
No.
All right, I'm going to show you what's entitled Discovery Acknowledgement. Defense counsel, have you received all the discovery in this case and did you review it with your client?
I have, Your Honor.
Mr. Berry, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge, we're only proceeding on paragraph A of count 1.
No objection, Judge.
All right, Mr. Berry, I'm showing you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with burglary of a building with intent to commit theft? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call on the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes,
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Berry, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm going to show you the plea bargain page. Did you review this page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on paragraph A of count 1 only. Punishments be assessed at 18 months in the state jail facility. There are no applications. They will take in consideration 2022 CR 8757. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it and did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense is charged in paragraph A of count 1. How do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Judge, State's Exhibit 1 and all attachments.
Your Honor, I've reviewed that with my client. We have no objections.
Mr. Berry, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, my client's been homeless for quite some time. He went into this house and he knew wasn't supposed to be there. He took some items and he's here today to try to make amends with not only the owner of the home, but with the court and to, do what he's supposed to do. Do what he needs to do.
All right,
We have
Mr.
the court to follow.
All right, Mr. Barry, unless that circular saw was going to be used to build your home, I don't understand breaking into a building and taking equipment. The fact that you're homeless does not give you free reign to break into people's property and to do other things when I know, everybody knows there are different places that you can stay at. There's Haven for Hope. There's the Salvation Army. There are so many places that you can stay at as opposed to breaking into other people's places. You understand? All right, I'm going to follow your agreement. I'm going to sentence you to 18 months in the state jail facility. Give you credit for any time served. Take in consideration 2022 CR 8757. Is there anything else with regards to sentencing? All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney, okay?
Yes, sir.
All right, we can go off the record. What are all these tattoos for?
Just prior time not being incarcerated, just
Okay.
stupid decision.
All right. And I have no issue with people getting tattoos. I'm always interested in the life story behind the tattoo. Because I see your name on the top side. Why?
Just it was a spare the moment type of thought, you know what I mean? Like everybody else doing it, so I thought I should do it too.
And when did you get that?
About 2 years ago.
Was that while you were in custody?
Yes, ma'am.
Okay. Any of your tattoos from when you were not in custody? Okay. All right. Are you planning on getting any more?
No, ma'am.
All right. Good luck to you. Okay. Do better.
Thank you.
You're welcome. Thank you. Oh, it's been. Ah.
I think that's even looking for the violation.
Okay, Osoro's here. All right, Olivia Osorio. Can you come forward? Thank you. What, can you see what date her court date is for us?
December 1st.
Oh, it's December 1st?
That's our first appearance.
Oh, yeah, you need to.
Here we go.
Yeah.
All right, so you're set for December 1st, your attorney is telling me.
First appearance, yes, sir.
Okay. So have you been in touch with pretrial services?
Yes,
All right, do you have their contact information now?
I have an officer, yes.
All right, and you know that you got to stay in contact with them, right?
Yes.
All right, if you don't stay in contact with them, what's going to end up happening is you're going to get a violation report, and we're not going to have any more conversations because this is your third violation report. And I know your attorney was able to get you in contact with them. So there cannot be a fourth violation report from you, okay? All right, do you need an actual reset form for your December 1st date?
She knows.
No, I know.
Okay, all right, 9 a.m.
Thank you. Thank
You're
you.
welcome.
You should excuse you.
Yes.
Can I get that reset forward back to the misdemeanor 1 yard?
Sure.
Thanks, Sharp.
You're welcome.
Oh, congratulations. Re-election well deserved.
Oh, thank you so much. I appreciate that.
And the Tigers are surprising.
Oh my gosh, it's so funny because Cornelius Cox said he was having dreams of Florida winning a championship. He said he couldn't even sleep at night before the season started.
Tell that to be true, but you must be thinking of some other sport.
Yeah, I'll let him know. Brenda, are you okay? They're saying the dry cough may be a sign of the flu or something. You know, people say you should stop Googling your health conditions. I've Googled some and
Yeah.
I'm currently alive, even though it said I shouldn't be.
Yeah, I should be dead.
Yeah.
I mean, that.
The same thing's filed on all of them.
Yeah.
Yeah,
I just.
that's fine, whatever. I saw the other one was filed on all of them, so I just
Yeah.
did it just to
Oh,
be safe.
okay.
What goes away, doing that all at one time, so I have to go back
Yeah.
into case each separate, you know?
All right, and so this is something we had already discussed, correct? Your motion?
Yeah, you would, he'd asked for a PR bond and you had had the PSI information on his background and the letter had been filed by this.
And I wanted to know where he wanted to, where he's gonna live.
Well,
correct?
yeah, I just thought it might be a good idea, and you had remanded him without bond because you picked up some new charges on the case. He has a total of seven cases, Your Honor. I've got the listing, if you need to know what each one is.
Oh, no, I have the files.
Okay, I said with the bond,
Yes.
just say that. Yeah, we've been waiting on, that letter, and I talked to her again last night. She just emailed me something last night. So
All right, and have you talked to the, conferred with the state on a bond amount?
I just talked to make sure they had my paper. Yeah, we didn't discuss it. We can talk about that really quick.
All right, and let me give you this, but I'll need it back just in case the state doesn't have it. This is,
They already said that, oh, that, what's that?
that's his history and everything.
Oh, I'm assuming they have that.
Okay. I didn't have the other file. No, I only had that one. I was wondering where it was. All right, Mr. Reyes. Your attorney is zooming in, so just give us a moment.
Yeah.
Okay, are you guys ready? They can't be reading. Okay, just let me know.
Okay. Feel like I'm all out of sorts. We're ready on Mr. Process.
All right, everyone, make sure that you're silent in the box. The court is calling 2022 CR 4826, State of Texas versus Daniel Rosas. Can I have parties approach and announce for the record? For the state? Defense?
Doug Campbell for Mr. Rosas.
And are you Mr. Rosas? Mr. Rosas, I'm showing you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Daniel Rosas who was placed on community supervision in 2022 CR 4826 for the offense of violation of sex offender registration annual on June 6, 2022 for a term of 5 years? Is that you?
Yes, ma'am.
State?
It's a violation of condition number 4 in Bexar County, Texas. The defendant, Daniel Rosas, did then and there fail to report to the supervision officer as directed for the months of July, August, and September 2022 in violation of condition number 4.
How you plead to that? True or not true?
True.
State?
Judge, we're waiving the other violations.
Any objections?
No objection.
Do you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and sentence you to 5 years in prison and up to a $1,500 fine? Did you understand? Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am. True.
Court will find violation of condition number 4 true. Is there an agreement?
Yes, Judge. The agreement is to alter and amend, adding 6 months bi-monthly reporting and a TAP evaluation and follow the regs.
Is that the agreement?
It is, Judge.
Are you asking the court to follow that agreement?
Yes.
Are you waiving your right to appeal?
Judge, one thing we would ask that the TAP evaluation be done. With Mr. Rosas.
No. Thank you. All right, TAP evaluation while in custody. Follow all recommendations. There's going to be GPS. Full. Until further notice. And we'll defer the fees. Anything else? Anything else, Mr. Rosas? All right, Mr. Rosas, you don't report. What's going to end up happening is you're probably going to end up going to prison for 5 years. Do you understand?
Yes.
All right, good luck to you.
Thank you.
You're welcome.
May I be excused?
Yes.
Thank you.
Thank you. Very thanks. God bless.
Mr. Toshi, do you need to confer with the state?
I would like to, Judge, if somebody somehow is available to chat with me, yes.
All right, and your case, is it criminal trial division or family violence?
It's CTD, Judge.
All right. Is there anyone from CTD who's able to either confer with Mr. Toshi on Zoom or call him?
Yes, sir.
All right, so either Mr. Sanders or Ms. Sparks will be calling you.
Alrighty. Calling?
Yes, they're going to call you.
That's fine. Okay.
All right, thank you. Jeremy Alvarez Pettis.
That's my case, Judge.
All right, so where are we on this case?
Judge, the state's making me a new offer
Okay,
on the case, and I'd just like to see if I can get a couple weeks, and I think we hopefully should be able to work it out.
do you have all the discovery?
I do.
All right, let me see. State if you can file the acknowledgement of discovery. And how much time are you asking for?
Judge, if you give me 2 weeks, I think that'll be enough.
Let me see.
I'm with you on the 29th, I think.
All right, you want me to put it on November 29th?
It'd be great, yes.
All right, so we'll come back on November 29th, and that will be your plea deadline date. At that time, you need to ask let the court know whether or not you're accepting the state's offer. If you choose not to accept the offer, the court will not consider any plea bargain agreements without good cause. Otherwise, you have to plea open to the court. You understand? All right, thank you.
Thank you, Judge.
You're welcome. And Mr. Mauer, if you can just remain so that they can give you the discovery
I
acknowledgement.
have one other case.
Okay.
My client's got a shy black.
All right, thank you. All right, are we ready on Mr. Jason Hickman? All right, the court is calling 2022 CR 10323, 2022 CR 8518, 2022 CR 8519, 2022 CR 8520, 2022 CR 8521, 2022 CR 10324, and 2022 CR 10325, State of Texas versus Jason Hickman. Can I have parties announced for the record for the state?
Sanders.
Defense.
Carl basically on.
And are you Mr. Hickman?
Yes, ma'am.
All right, we're back here on a motion to have your bond set. Because you've been remanded without bond. And 4 of your cases, that's cause numbers ending in 8521, 20, 18, and 19, correct?
Correct, Your Honor.
All
There's
right.
bond set on the other 3.
All right. And defense has filed a motion, state, and the motion is entitled Motion or Notice to Use Out-of-Court Document in lieu of Witnesses' Testimony. And I do remember this was something that the court wanted to know where he would be living. Any objections, state?
No, Your Honor.
All right, the court has reviewed your motion. All right, have both of you all had a chance to confer on a bond?
We have, Judge.
Yes, Your Honor, we have.
And is there an agreement on the bond?
No, Your Honor. The state's asking that the bonds be doubled, and I know that that's what the court does fairly often, and asking the court to consider.
Well, no, I mean, that's not what I fairly do often. I just listen to whatever
Yeah.
evidence is presented to me and make a ruling.
I'm asking the court, Your Honor, as you see, I've talked to this lady a couple times, and she's told me that she will make sure that he follows whatever conditions, and if he doesn't follow, he has no hesitation, letting someone know that he's violating whatever conditions they are. She's known him for about 10 years. She's going to help him, but he's going to have to work, which I know he said he can do, and help support her, that she's willing to provide support for him and make sure or support him or help him follow whatever conditions. I'm asking the court, Your Honor, to set a total bond on all the cases of about 150,000, which would be kind of in between the two, between what's set now and doubling. If you double all the bonds, it would be a total of $200,000 on all these cases. He has 50,000 on the ones that are already set, so that would be maybe 100,000 on the.
All right, I'm just trying to see what the offense dates are in these cause numbers. Just 1 second.
Judge, I have them with you.
Yes.
It is May 19th of 2022. And the following cause numbers 2022 CR 8521, 2022 8519, 2022 8520, and 2022 8518.
All right, and the remaining cause numbers, are
It's-
they the same offense date?
Yes, Judge, August 31st.
And that's 2022?
Yes, Your Honor.
All right, state, what are you requesting for bonds?
Judge, we're asking that you double the bond in each of the cause numbers. Not getting to too much of his criminal history, but as you can tell from the highest level offense, which is the 2022 CR 8521 on the face of the indictment, he is a habitual offender
If you look at the court's file, there was a violation report issued on August the 10th of 2022 for a GPS tampering. And so he actually had a warrant for these cases before he even picked up the new offenses.
All right, so in 8519, what are you requesting, state?
8519, we are requesting 40,000.
And in 8518,
10,000.
and in 8520, that is the possession less than a gram.
20,000.
And then in 8521,
80,000.
all right, defense is your motion, so I'll hear final argument from you.
Your Honor, my client also expressed to me, if he wanted to, if the court sets his bond and if he's able to post a bond, he wanted to make sure it would be okay with the court if he, during the time he's on bond, he tried to get into some recovery, like lifetime recovery. If the court would be okay with that, when he's out, and don't guarantee he did, but he'd express his desire to do that and make sure that they are with the court on it. I understand he does have an extensive history. I've looked at what the court's files show, they are habitual. And I think he's discussed with me that he really wants to try and turn things around. He's able to get a job. He said he could even work on a GPS house arrest, he told me, and that would be no problem. He could do that if that's what the court wants, where he's on house arrest, and he could, his job, he could do out of the house. And he could probably explain that better, what type of job he has.
All right. Is there anything you wish to say, Mr. Hickman? If you do wish to say something, you'll be placed under oath.
This one.
No, I mean, do you want to be placed under oath?
Be placed under oath.
And you will be cross-examined.
Sure. Yeah, I'm taking every question, you understand that?
All right, so here's the thing, you've been remanded without bond. And so my question again is, you've been remanded without bond. Do you want to subject yourself to cross-examination? I mean, it's completely up to you and your attorney. All right.
This time, what he's expressed to me on it, he does like draft work on a computer, he does a draft. That's what he's able. That's why he's.
No, I'm not going to take any information from him and what he's told counsel unless he wants to subject himself to cross-examination.
That's fine.
So, does he want to subject himself to cross-examination?
My recommendation would be no.
All right. So in cause number 2022 CR 8518, the court will set bond at $5,000. That's full GPS. And cause number 2022 CR 8519, the court will set your bond at $40,000. That's full GPS. And cause number 2020 CR 8520, the court will set your bond at $5,000, full GPS. And cause number ended in 8525. The court will set your bond at $150,000.
Good, what's the card number of that?
That's 2022 CR 8521. And that's full GPS. Mr. Hickman, you cannot tamper with your GPS. You understand? All right, and the court is basing its decision based upon the argument that the court has heard, also the updated criminal history that has been tendered to the court and that has been reviewed by both state and defense. And the court, I believe the defendant has been indicted on some cases as a habitual. Is that correct?
Yes, sir.
That's correct. Your
All
Honor.
right. Is there anything else from either side?
No, so she said on the 8521 is 150 just for that charge.
Yes, and full GPS. All right. Is there anything else?
Not this time. So,
All right. Thank you.
thank you.
And on Hickman, I'm sorry, Mr. Basil, on Hickman, we need a reset date. Does he have a current date for his case? All right, so we're gonna come back on his case on December 13th, just to see where we are. All right.
On the White Basin and then on Brianna Gutierrez, I've already conferred with the state. They made an offer. She's not accepting it, so we just probably need to approach the judge and let her know.
What was that?
Brianna Gutierrez.
Okay.
And then I'm gonna need to approach the judge about some other matter. I'm hoping the judge won't embarrass me.
Okay, I'll be right back. All right, thank you. Hickman is going to be reset December 13th. And I will put on here the map side. Okay, I'll take that up first.
Have Espinosa, there's two cases. It's a first sitting in the second sitting. We can bring him back in about in half 2 weeks. I'm looking for the issue.
No. Oh, I'm so sorry. This doesn't one of the process, either one. Oops, and also this. All right, so we'll take up this matter just as soon as the court reporter comes in. I'll take you first. Okay. All right, she should be back in like 2 minutes. Thank you. All right, who's here on Raymond Alejandro? Good morning. What is happening with this case?
If we talk to Mr. Villarreal.
All right, Mr. Alejandro, come up. Right, so it's a plea deadline date. What are we doing?
We're requesting a trial.
Okay. All right, I'm gonna bring you all back on. I'm gonna bring you all back on December 2nd. And at that time, I'll be able to give you a jury trial date.
Okay.
And maybe a very quick turnaround. Okay.
There, just to let the court know, Mr. Villarreal and we've discussed, the state's going to issue a subpoena for some records, and so hopefully by that time we'll have them proceed from there.
All right. All right, and state on Mr. Alejandro, if I could have a acknowledgement of discovery. And Mr. Alejandro, your plea deadline date has expired. What that means is that the court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have to plea open to the court. Do you understand? All right, thank you. All right, they'll give you a reset form.
Thank you, Judge.
You're welcome. Could I see the,
Excuse.
yes. Could I see the parties on Alberto Paulo Serrano Santos? I hope I didn't get anything out of order with that.
Little bit, Judge, but
Okay,
Santos, I would be sufficient, I think.
okay. See, this is the way they have it on the docket sheet for me. All right, the court is calling And if everyone in the box could please be quiet. Court is calling 2021 CR 2719, State of Texas versus Santos Serrano Paula. Could I have parties announced for the record for the state?
Catherine Pollard.
Defense.
Albert Gutierrez.
And are you Mr. Paula?
Yes.
All right, we have an interpreter here. If the interpreter, if you could raise your right hand for me, please. Do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English? So help you God.
I do, Your Honor.
All right, you can lower your hand. Counsel, do you speak Spanish?
I do, Your Honor.
All right, I know the answer to these questions, but so that the record can be clear. And do you speak Spanish fluently?
I do, Your Honor.
And have you been able to communicate with your client in his language?
Yes, Your Honor.
And all of the documents that the court has are in English. Were you able to go over those documents with your client in Spanish?
I was, Your Honor.
Mr. Paula, were you able to understand all of these documents?
Yes.
And were you able to communicate with your client in with your attorney in Spanish?
Yes.
All right, counsel, have you received all the discovery in this case and did you review it with your client?
I have received it, Your Honor, and I have reviewed it with.
All right, the court will find that the state is in compliance with discovery. Mr. Paula, did you review a document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, I believe you're proceeding on count 4 and waiving all other counts.
Any objections?
No objection, Your Honor.
No.
Mr. Paula, I'm going to, did you review a document entitled Court's Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it?
No. I'm sorry.
Okay. Did you review a document entitled Court Admonishment and Defendant's Waivers and Affidavit of Admonitions with your attorney?
Yes.
Did you understand it?
Yes.
And did you sign it? And
He explained those to me.
okay, thank you. And did you sign it in all the appropriate places?
Yes.
Did you understand in count 4, you're charged with the offense of indecency with a child by contact? That's a
Yes.
second-degree felony.
Yes.
The range of punishment is anywhere from 2 years to 20 years in prison and a possible fine of $10,000. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow that plea bargain agreement. If for any reason the court does not follow that plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent.
Thank you.
Oh,
Yes.
gracias. Okay. Or should I say Donata?
I'm sorry.
No problem. Did you understand by entering this plea, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, yes, Your Honor.
Mr. Paula, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No,
Has anyone promised you anything other than the plea bargain agreement?
no,
Are you satisfied with the way you've been represented?
yes,
Are you a U.S. citizen?
no,
Counsel, did you advise your client of the consequences of pleading no contest or guilty in the application of federal immigration law?
I have, Your Honor.
Did that advice include possible consequences such as deportation, exclusion from admission to the United States, or the denial of naturalization?
It did, Your Honor.
Do you believe your client understands the consequences of entering into a plea bargain agreement in this case as it relates to his immigration status?
I do believe that, Your Honor.
Mr. Paula, did your attorney advise you of the consequences of pleading no contest or guilty in the application of federal immigration law?
yes,
Did that advice include possible consequences such as deportation, exclusion from admission to the United States, or the denial of naturalization?
yes,
And do you understand the consequences of entering into a plea bargain agreement in this case as it relates to your immigration status?
yes,
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it?
yes,
According to the plea bargain agreement, the state is proceeding on count 4. They're asking that your punishment be 10 years in the prison. There is no fine. There are no applications. There's Chapter 62 registration, and there's to be no contact with the complainant. Did you understand that to be the plea?
yes,
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Did you review the paragraph entitled waiver of appeal with your attorney? Did you understand it? Did you sign it in both places?
yes,
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes,
Counsel, have there been any such motions?
None, Your Honor.
Then to count 4 in the indictment, how do you plead? Guilty, not guilty, or no contest?
guilty,
State any evidence.
Yes, Judge, we'd offer what's been marked as State Exhibit 1.
Any objections?
No objection, Your Honor.
Mr. Paula, did you review a document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it, and did you sign it in all the appropriate places?
yes,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty of count 4, indecency with a child contact. Are we proceeding with sentencing?
No, Judge, we're asking to reset it for victim impact.
All right, and what date?
Judge, let me.
Okay. And is there a bond set in this case, counsel?
I'm sure there is, Judge. I'm not aware of it. I don't remember, but
Judge, anytime after today.
All right. So we can set it for November 28th. Is that good for you, counsel?
I'm just thinking the day of the week is.
It's Monday.
Okay, that's fine.
All right, so we're gonna recall this for sentencing on November 28th. And the court will remand your client without bond. And issue a judge's warrant. So we will be back on November 28th.
Thank you, Your Honor.
All right, thank you.
Maybe excuse you?
Yes, thank you so much. Have a great day.
Excuse you.
Brianna Gutierrez. Going once, Brianna Gutierrez, where's your attorney? All right, just have a seat. Miguel Espinoza.
Here, Judge, may we have a minute? We're still comparing.
All right, thank you. Adriana Harrison. Okay, he's in his office.
Couldn't find it.
Okay. All right, we'll wait for him to come back. It's not a problem. Frederick Condell. Thank you. Yes.
Actually. Can we talk you out the back hall in there?
Sure.
Just for a minute?
All right, everyone, just give me a moment, please.
Yes, ma'am.
Don't see the attorney.
Okay, Judge.
Oh,
Let's go call him.
okay. Noel Balderas. All right, what is? Are you ready to proceed?
Yes.
All right, court is calling 2017 CR 1914W, State of Texas versus Noel Valderas. Can I have parties announced for the record for the state? Brittany Sparks. Defense.
David McLean for the defense.
And are you Mr. Valderas? All right, I'm going to show you what's entitled motion to enter adjudication of guilt and revoke community supervision and First Amendment motion to enter adjudication of guilt and revoke community supervision. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
Are you the same Noel Martinez Valderas who's placed on deferred adjudication in 2017 CR 1914W? Hey, I'm sorry, if you guys could be quiet in the box. For the offense of hinder apprehension felon on February 6, 2018 for a period of 2 years. Is that you?
Yes.
All right, state.
Yes, Judge, I'm reading from the first amended. Violated condition number 5 in Bexar County, Texas, the defendant Noel Martinez Valderas did then and there fail to report to the supervision officer for the months of May, June, July, August, September, October, November, and December 2018, January, February, March, April, May, June, July, August, September, October, November, December 2019, and January 2020 in violation of condition number 5.
How do you plead to that? True or not true?
True.
We'll waive the other violation.
Any objections to the state's waivers?
No. No, Your Honor. Thank you.
Do you understand by pleading true to violation of condition number 5, the court can find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand that?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
You need to speak up.
Yes, ma'am.
Court will find violation of condition number 5 true. Is there an agreement?
Yes, Judge, we're asking that you grant the motion to adjudicate and place the defendant on probation for 4 years with an underlying sentence of 4 years in the prison.
For understanding, Judge.
All right, why are you not reporting?
I'm homeless. My family lost their house in 2016. I was homeless for the first 4 years.
But what does that have to do with you not reporting? I don't understand.
I was living face to face. I didn't have no transportation at the time. My words was to give my mom a place.
Okay, I can't hear you.
My words was to give my mom a place at home. I was thinking about reporting, but I was thinking about being home for my mother.
But I don't know how you're gonna do that if you're at the prison. How old are you?
I'm 32.
Any gang affiliation? Do you have children?
Yes,
What are their ages?
14.
So where was your 14-year-old when you were homeless?
Well, he's being remarried.
So you don't take care of your 14-year-old? That's
I
what
do-
you're trying to say to me?
I think child support.
Mhm. All right, this is what the court is going to do. The court will deny the motion, alternate amend conditions. I'm sorry, the court will find you guilty, alternate amend conditions to include, well, to sentence you to 4 years in prison, suspended and probated for 4 years. Parenting classes. 200 hours of community service restitution, 40 of those hours be waived if you provide proof of the COVID vaccination. Court is not requiring you get the COVID vaccination, but if you get the COVID vaccination, the court will waive 40 of those hours. The court will waive the remaining hours once you complete parenting classes. You to have employment, proof of employment within 30 days. There should be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. I'm going to want field visits. Where are you staying now? Do you have a place?
Yeah.
Who are you staying with?
Me and my mother.
All right, there's going to be field visits 2 times per month. The UA hotline. Is there anything else that he needs probation?
Your Honor, on the UA hotline, how often would you like tested?
Once a week for at least 3 months.
That'd be all.
Is there anything else you need from the court in order to be successful?
No.
All right, I'm going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it? And this is a plea bargain agreement that you reached with the state, correct? And you wanted the court to follow that agreement? And were you waiving your right to appeal? All right, then, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record, Mr. Balderas. From here on out, you need to start asking yourself, is what I'm doing can result into me going to prison for at least 4 years? Do you understand? All right, all you have to do is call probation. If there's a homeless situation, just pick up the phone and call them. Or either go to their office and say, I'm homeless. Can you help? All right, good luck to you.
Thank you, ma'am.
You're welcome.
Thank you, Judge.
You're welcome. Danielle Gomez. Hello, good seeing you. All right, court is calling 2022 CR 4510, State of Texas versus Danielle Gomez. Can I have parties announced for the record for the state? Defense?
Valentina Cogut from Ms. Gomez.
And are you Ms. Gomez?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I have received and reviewed with my client.
Court will find that the state is in compliance with discovery. Ms. Gomez, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment? State, are you proceeding on the indictment as presented?
Yes.
Ms. Gomez, I'm showing you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand you're charged with the offense of theft of aluminum, bronze, copper, or brass as a state jail felony? The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your agreement and give you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you are giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she is and she was.
Ms. Gomez, has anyone threatened you, coerced you, or placed you in fear to get you to end this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 9 months in the state jail facility. There are no applications. The state will take in consideration grand jury number 734-297. And you're to enter a plea in cause number 6955533. The state will offer judgment satisfied. There's to be no contact with any Lowe's or HEB. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, yeah.
Then to the offense is charged. How do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Judge, States Exhibit 1 and all attachments.
No objections.
Ms. Gomez, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing? Anything you wish to say on behalf of your client?
Your Honor, she's accepted responsibility and we're asking credit for time served and we would ask the court to follow the plea bargain.
All right, the court will follow your plea bargain agreement, find you guilty, sentence you to 9 months in the state jail facility, give you credit for any time served, take in consideration grand jury number 734297. There's to be a judgment set and county court cause number 6955533. There's to be no contact with any Lowe's or HEB.
Yes, ma'am.
Anything else from either side with regards to sentencing?
No, Your Honor.
Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to the attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. We can go off the record. You better get your life in order. Otherwise, you're going to end in and out of the Bexar County Jail, in and out of prison.
That's what I have time to do, ma'am. Thank you.
All right, good luck.
Thank you. Thank you.
All right, Brianna Gutierrez. Brianna Gutierrez. I'm sorry, your attorney is not here. We're going to take care of you today, though. Miguel Espinoza.
We're almost there, Judge.
All right, thank you.
Judge, can I interrupt for 2
Yes.
seconds? On Frederick Condell that we spoke about a few minutes ago, you said November 28th. Would it be possible to do it sooner? Not just to get him
No, because we're not going to be here for the week of
Next week.
November 21st.
Okay, so next week you're on.
Yes.
Okay. So we can't do it till the, thank you, Judge.
You're welcome.
We can't do it till the 20th.
Are we ready on it? Julian Reyes or no? He needs to reach out to me to get a reset. All right. You can let them know that Reyes can go back. He is 14C. All right, and then on Mr. Reyes, that is being recalled for November 28th. Dwight Basson. All right, Jose or Josue Carvajal.
It's Josue.
All right.
We are ready, Judge.
All right, if you'll come forward.
Judge, did you ever see the movie Along Came Polly?
Yes, I did. Okay, you and me are probably the only few people who watched that.
Yeah.
Oh, you've seen it? Oh, my gosh. Well, I know Marcus hasn't. Brenna, have you?
I have seen it.
Okay, this is shocking. Buy a lottery ticket.
The movie Along Came Polly.
Yeah. All right, court is calling 2022 CR 5498W, State of Texas versus Josue Carvajal. Could I have parties announced for the record for the state?
Marcus Sanders.
Defense.
Robert Mauer for defendant, Your Honor.
And are you Josue Carvajal?
Yes, ma'am, I am.
All right, I'm sure you what's entitled motion to enter adjudication of guilt and revoke community supervision and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation. Did you review those documents with your attorney? Did you understand them?
Yes.
Are you the same Josue Carvajal that was placed on deferred adjudication in 2022 CR 5498W for the offense of unauthorized use of a vehicle on June 7, 2022 for a period of 2 years? Is that you?
Yes, ma'am.
All right, state.
We'll go forward on the motion to supplement. Condition number 4, in Bear County, Texas, the defendant, Josue Carvajal, did in there fail to report to the supervision officer as directed for the month of September 2022 in violation of condition number 4.
How do you plead that to that? True or not true?
True.
We'll waive the others.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court can find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. Is there an agreement?
There's Judge, we're asking that you deny the motion, alternate one to order safety but hold it in abeyance. We're also asking that you order intensive outpatient treatment and a GPS for 90 days.
And Judge, on that GPS, he owns a food truck. So I asked the court if, I'm not sure if probation supervises the same as pretrial, just so he'd be allowed to operate his food truck.
All right, and Mr. Carvajal, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Why are you not reporting?
I just had a lot of stuff going on and at the same, I couldn't, I didn't make it on time and I always had failed to report.
All right, if I drug test you today, what are the results
did.
going to be?
You did. It was positive.
Okay,
There was no levels. He said he hasn't smoked in a while. I was hopeful the court would, I think we talked about doing weekly UAs, just so we can keep checking his levels. I had a long talk with Mr. Carvajal.
oh, so people knew to test him before he even came here, or I requested, I appreciate
I
that.
think the parties saw the writing on the wall.
And Judge, I'm sorry, I missed part of the agreement. It was 90 days GPS with 90 days weekly UAs on the call line.
Okay. And can he afford GPS?
Probably not. I am retained, I would say I'm partially retained, Judge. If the court could give him some consideration on the fees for GPS, I'd appreciate it.
Might I have heard of your food truck? What are you serving?
I go to different routes, actually. I go to like construction sites and it's just different places. I don't stay in one spot.
What kind of food?
What do you serve?
I sell tacos, plates, burgers. And I have the little side where it's like a little mini truck.
All right. And he pronounced tacos appropriate, with the accent on it. So I know they're probably good tacos.
Oh, yes, ma'am. They
Oh, they are. Yeah. How much are your tacos?
$3 each and plates are 10. And then we have
How
snacks.
many tacos you get for 3?
Masada, pastor y carnitas.
See, look at that.
Oh, help me with that.
It doesn't gouge the consumer.
Okay. All right, this is what the court will do. The court is, because if he's working on his food truck, if you do the UA hotline, I mean, who else is working in the truck with you?
There's actually, it's 4 trucks. My dad owns a big one, like the big old one, and then we have 3 small ones, like little trucks.
Yeah, so my thing is yes.
We have had it, if Your Honor would agree, is if you do ask, or the IVR hotline asks for them to go ahead and submit, that you give them 24 hours and then they go within that 24 hours.
Okay, we can do that. All right. So this is what the court is going to do. Court is going to do the UA hotline until further notice. And we'll do field visits 1 time per month. And probation, is it easier for probation if that coincides with his reporting or no? Because
Yes.
all right, so we're going to do field visits 1 time per month. And we'll do regular reporting by Zoom or in person. In probation, if you want that regular reporting to count for the field visit, it can. And if there is another positive UA, which there should not be, then I'm going to want 90 sober meetings in 90 days. And do we need an updated tab?
Your Honor, I would say we need a tap period.
All right, and then we'll do a TAP evaluation, and we'll do that so we can have it on record. If for any reason he tests positive and the TAP recommends inpatient treatment. We'll start with outpatient treatment.
Judge, on that, I guess I'd ask the court to check his levels. As long as the levels are going down and we can see he's not using as opposed to
Yes.
a high THC in his body. I just don't want him to get revoked if he's quit smoking, his levels are going down.
Okay.
So UI hotline weekly to test levels. Once a negative baseline is attained, then
Then if there's a positive that comes after the negative, then we have issues.
Yep.
And nobody wants you serving their food if you've been using marijuana. All right, is there anything else from either side?
No, ma'am.
All right, know better, do better. All right, good luck to you.
Thank you, Judge. Appreciate
You're
it.
welcome. All right, it looks like we may start to be sending, when do we start sending people
We
back?
already have now.
Okay, thank you.
We just have.
Yes, because I'm like,
People now have two.
all right, because I'm like, other people will have to go back.
Think about it. Wendell?
All right, Jose Ramirez. Yeah. So I show he was in the hospital previously. So where are we now?
We're waiting still on some restitution that they haven't been able to get from their victim yard.
All right, state
And I've been
when,
dealing with mainly with Brian, but I know he's not here today.
okay. State, when do you anticipating getting restitution information? Will you be able to have that by December?
Yes, sir.
All right. So we'll reset this for December 6th. Is that good for you, counsel?
Define good, Your Honor. My calendar is
You
jammed.
want December 7th?
That week is bad, Your Honor, really.
No, it'd have to be that, or we can do December 12th.
You know, Your Honor, that would work best.
All right, so we'll come back on December 12th
Appreciate it.
and just get your reset form and your excuse.
Thanks, Your Honor. Appreciate
You're
it.
welcome.
Judge, on Miguel Espinosa, we previously withdrawn the MTR to refile. We were awaiting some drug results, which we have in. But to proceed if it was contested. But we've worked out an agreement for the MTR. Is it possible to have us, can we refile it right now and then have them plea on? Okay.
Yes.
Just all one, okay.
Yes, if there are no objections.
No, we're good.
Okay.
All right, push on.
Okay, could I see the rest of the files?
Yeah. You know what it is?
All right, Gutierrez.
Yes.
Okay,
Brianna?
I gotta get it to you. What?
All right, what is happening with this case?
The state made an offer on the case. Gutierrez is not accepting the offer at this time.
No, there's like, here's the thing, I'm gonna give you a plea deadline date. And after that date, the court will not accept any plea bargain agreements in this case. Do you understand? So this is being recalled for December 12th, and that's your plea deadline date. After that date, the court will not accept any plea bargain agreements in this case. Otherwise, you'll have to plead open to the court, and the court will only accept a plea if it's with good cause. Do you understand?
When is the court setting these matters for trial?
The plea deadline date is for the 12th.
Thank you, Your Honor.
Thank you.
You
Get a
got
reset
that?
form from Miss Gamboa.
Yes. I'm seated in the- Yeah, I'm just gonna sit front row on this.
All right, Mr. Cox,
Oh, yes, ma'am.
are you ready on Miss Harrison?
Oh, wait a minute. Had a problem, I'm not guilty on that.
Okay.
Yeah, say that.
All right, court is calling 2017 CR 8433W, State of Texas versus Adriana Harrison. And I think we're also calling. Yes. Oh. Look at this. Thank you. We're about to go without a record. I'm about to do it in shorthand. I took shorthand in high school. Do not leave.
Thank you. Thank you. Okay. Oh. It's a tough day. I got my lunch a little somewhere too.
All right, so this is coming November 28th. Oh, we're just waiting for the. All right, who is the person on Eric Victor? We're gonna bring that back on the 28th as well.
Yeah, he's done, he never brought him out. And he's on a walker, so it takes a long time. All right.
So we'll do it November 28th. All right, and Adam Stacy, that's a fugitive. All right, Manuel Adame. All right, now Condell, that's coming back on the 28th, right?
Makes a lot of things. It's like really gonna happen.
I'm not sure it's gonna be after that though. That's all.
Good. They're just taking a call. Thank you, Judge. Appreciate the court consideration.
All right, you're welcome.
Happy Thanksgiving.
Oh, happy Thanksgiving to you too.
Thank you.
Oh, no problem. All right, so we're on Harrison. Court is calling 2022 CR 8433W. And I believe that's the case that we're having to proceed on. Yes. Could I have parties approach and announce for the record for the state,
Michelle Hayden for the state.
for the defense? All right. Are you this Adrian Harrison?
Yes, ma'am.
All right, I'm showing you what's entitled motion to enter adjudication of guilty and revoke community supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Adriana Kiana Harrison who was placed on deferred adjudication in 2017 CR 8433W for the offense of forgery of a financial instrument on September 18th, 2017 for a period of 4 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 1, on or about the 9th day of July 2022 in Bexar County, Texas, the defendant Adriana Kiana Harrison committed the offense of assault in violation of condition number 1.
How do you plead to that? True or not true?
True.
State,
Will waive the remaining conditions.
any objection? All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
And it's the court's understanding that there is an agreement that has been reached. Is that correct?
That's great.
That is correct. The agreement is to proceed under 1244, revoke 4 days Bexar County Jail, and we'd ask that the judgment be satisfied.
That's great.
All right, and are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
The court will sentence you, will follow your agreement, find you guilty, grant the motion, sentence you to 4 days in the Bexar County Jail under 12.44. Give you credit for any time served, and the court will note that the judgment is satisfied. Counsel, if you could get another trial court certification for the court, please. And on this one, it's just changing the allegation that you're proceeding on, so everything's still the same. It's I'm sorry, what date did you give Myra Matthews? All right, I'm showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. Thanks for coming back.
Have a good day.
You too. Thank you, you too.
Judge, on the Miguel Espinosa, since we just refiled it, I guess it needs to be entered in the system.
Okay. Find that. Who's here on Dwight Batson?
That would be me, that's me, Your Honor.
I'm sorry. And I will get, this is the one that the state say they need to have an assistant. All right, thank you. All right, the court is calling 2022 CR 8643, State of Texas versus Dwight Batson. Can I have parties approach and announce for the record for the state? Defense.
We office marshal for Mr. Basson.
And are you Mr. Batson? Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review with your client?
Yes, I have reviewed it with Mr. Basin, and the state has met their burden.
All right, the court will find that the state is in compliance with discovery. Mr. Basin, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
State, are you proceeding on the indictment as presented?
No, just proceed on count one, waiving count two.
Any objection?
No objection to the state waiving count two.
All right, can we go off the record for a moment? Mr. Basin, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with the offense and count one of possession with intent to deliver controlled substance, penalty group 1, 4 grams to 200 grams? That's a first degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and give you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Basson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, state is proceeding on count one. Punishments be assessed at 10 years in the prison. There's no application for deferred adjudication. State recommends community supervision. They're taking in consideration 687,856, and there's $57 restitution to SAPD for drug testing. Did you understand that to be the plea? Defense,
Yes.
state?
Yes, Judge.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that document? Well, that paragraph with your attorney. Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 10 years. There'll be a TAP evaluation and 150 hours community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then how do you plead to count one, guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. State offers states exhibit one in its attachments.
Any objection?
No.
Mr. Basson, I'm showing you what's entitled waiving consent to stipulation and testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits one and attachments and review the same. After reviewing states exhibits one and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are we proceeding with sentencing?
Well, Your Honor, yes.
Anything you
Yeah,
wish to
well-
say on behalf of your client?
Yes, well, I do want to say this. My client is bringing to my attention his concern about possibly going to residential treatment for 9 months or more. And as such, he's inquiring if he could he was offered 2 years prison on account 2, and he's inquiring if he can do the 2 years prison. I told him, I don't know what the judge is going to do with respect to.
Is that the agreement, 2 years?
Yes, Judge, that was the offer.
That was the offer.
I think at some point he spoke to probation and said he didn't want to do this. And so I guess we just wanted to be clear what he wants to do. So if we can have a moment to step back.
Yes.
Judge.
Yes. Thank you.
You're welcome.
Let's just continue.
Do y'all want to sit and talk about it and I can
Well,
take another
Judge,
case?
I just want to bring some attention to the court, and I've explained it, and I'll put it on the record, explaining to Mr. Basin, is that he understands he offers 10 years probation, 10 years to do probated and suspended for 10 years. He's wanting to see if he can get that lowered if he does well on probation. I told him that question cannot be answered here today.
No, it cannot.
That question would only be answered when you're on probation, if you're completing it
And
successfully.
when you say lowered, you mean lowering the length of time he's on probation?
He said what?
When you say lowering, are you talking about lowering the length of
Well,
time he's on probation?
he was wanting at some point down the road to come and file papers with the court and saying if he could be terminated early. I told him that question cannot be answered today.
No, not that. I'm more worried about all the presents and stuff and all that. Because I just got off probation. I've already did drug court, completed it. Intensive outpatient program, completed it.
Well, here's the thing, Mr. Basin, I want you to understand something. When people come to me, they can't write their own program, because if they could write their own program and do well on it, we wouldn't be here.
I understand,
Yeah.
I understand that. I was just trying to get the information to find out to help me make my decision. You know what I mean?
Oh, yeah, I can't give you a precursor to what my ruling will be. You all have entered into an agreement. And if I accept that agreement, that's the agreement that's going to be going with. It's not going to be, oh, now I see the judge is doing this, so I want to do something else. That's not the way it works here. So if I place you on probation and follow this agreement and your underlying sentence is 10 years, and then you want to come back and do something else and say, well, I didn't know it was going to be like that. I want to do 2 years or whatever. Then what will end up happening is you all can present your argument, and then I will make a decision on whether or not to send you to prison for up to 10 years or something else. And in this case, it will be a minimum of 5 years under count one. So you all can discuss it, and I'll take up another matter.
I'll explain this.
All right, court is going to call 2021 CR 0741, State of Texas versus Miguel Espinoza. Can our parties announced for the record for the state,
Michelle Hayden for the state.
for the defense?
Alfonso Otero on behalf of Mr. Espinosa. Good afternoon, Judge.
Good afternoon. And are you Miguel Espinoza?
Yes.
All right, is this the appropriate? Let me see. Is this the correct clause number?
No, we have the two new cases on the docket, but the MTR is on another case, which is the one he's on probation.
Okay, I don't have that file. All right. So can I have parties announced for the record for the state,
Michelle Hayden for the state.
for the defense?
Alfonso Otero on behalf of Mr. Espinosa.
And are you Mr. Espinoza?
Yes.
Mr. Espinoza, I'm going to show you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that document with your attorney? Did you understand it?
Yes, I did.
Are you the same Miguel Espinoza who was placed on deferred adjudication for the offense of aggravated assault with a deadly weapon on April 29, 2021 for a term of 10 years? Is that you?
Yes, sir.
All right, state?
Judge, can I see that?
Yes.
Violated condition number 1, on or about the 31st day of July 2022 in Bexar County, Texas, the defendant Miguel Espinosa committed the offense, a violation of bond / protective order in violation of condition number 1.
How do you plead to that? True or not true?
And judge will waive the remaining allegation.
Any objections to the state's waivers?
No, Judge.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand? Knowing that, do you still wish to plead true to violation of condition number 1?
Yes.
The court will find violation of condition number 1 true. Is there an agreement?
Yes, Your Honor. The agreement is to enter an adjudication of guilt, sentence the defendant to 4 years in prison. Will take into consideration cause number 2022 CR 8739 and 2022 CR 8740. And we'd ask for a no contact order with Moses Marie Reyes, the victim on those cases that are being taken into consideration.
And could you spell the first name?
It is Moses Marie, last name Reyes, Reyes.
All right. All right, is that the agreement?
Yes, Judge.
Are you, Mr. Espinoza, is that the agreement?
Yes.
Are you asking the court to follow that agreement? All right, the court will find you guilty, sentence you to 4 years in the prison, give you credit for any time served, taking consideration 2022 CR 8739, 8740. There's to be no contact with Moses Marie Reyes, Sabrina Lopez, Micaiah, Makhia, Mesa, Mesa, Edith, Miguel, Esnet, Esined, Espinoza, Alyssa Espinoza, Nick Lopez, Denise Alejandro, there's an affirmative finding of a deadly weapon. And state, was this a family violence case?
I believe it was, Your Honor.
And there's an affirmative finding of family violence.
Judge, on Judith, Alejandro, that's his daughter. And they have arranged some visits through family courts, so we can just do, everybody else is not related to him, but if we can do a non-injurious harmful contact with the child.
The reason why I say no to that is because the court's original orders was for him to have no contact. And we're back here again. So that's an issue. So the no contact order will remain. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you weigh your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
And because this is a felony conviction and affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes.
And also, I see that he did have an immigration attorney appointed to him. Mr. Espinoza, were you aware of the consequences of entering a plea of true to violation of condition number 1 in this cause number as it relates to any immigration issues you have? Counsel, did you inform your client?
About the immigration consequences?
Yes.
Yes, Judge.
And that those consequences include deportation, exclusion from admission to the United States, and the denial of naturalization?
Yes, Judge.
And do you believe he understands the immigration consequences of having pled true?
He does, Judge.
Okay. And Mr. Espinoza?
Yes.
Do you understand by pleading true to those violations that you could have possible consequences such as deportation, exclusion from admission to the United States, or the denial of naturalization?
Yes.
Okay. And knowing that, do you still wish to have the court follow the agreement that you've reached with the state in this case?
Yes.
All right. Then the court, as previously stated, is finding violation condition number 1 true. The court is finding you guilty. And the court is ordering the 4 years in the prison, credit for any time served, taking in consideration the cause numbers as requested, and no contact with Moses Marie Reyes, Sabrina Lopez, Micaiah Mesa, Edith Miguel, Esnet Espinoza, Alyssa Espinoza, Nick Lopez, Denise Alejandro. There's an affirmative finding of deadly weapon and affirmative finding of family violence. And again, did you review the trial court certification of defendant's rights to appeal?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, I do.
And because this is a felony conviction and also an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you. Sorry. Yes. All right, I put the dismissals in there.
Could I get the steps from Mason's?
Yes. All right, and on Brandon Richardson, we're gonna call that back for November 28th. All right, and could I have a prosecutor on? All right, court is calling 2022 CR 8568, State of Texas versus Manuel Adame. Could I have state announced for the record?
Marcus Sanders.
All right, this hearing was scheduled at 9 a.m. It is now 1:08 p.m. Defense counsel Livingston has not appeared and the defendant has not appeared. State?
We're asking that the defendant's bond be forfeited and warrant issued.
All right, that will be granted. And the court will issue a bond forfeiture and remand the defendant without bond. Caroline, on the other case, it shows that he's a fugitive, the endangering a child. So. Oh, yes, I was on the DF on the unauthorized. Yes. Yes.
Never mind.
Okay. And let me see, Juliana Hughes or Julian Hughes.
Oh, that was receptive. That was just.
All right, okay, the 13th.
Julian Reed. Oh, no, you said Hughes.
Yes, Julian Hughes. Oh, that's set for December 13th.
Oh, yeah, I got that one.
Okay, all right, thank you. So I think that's Mr. Marshall is the last one we have.
Y'all have a happy Thanksgiving.
God bless you. Happy Thanksgiving. Bye.
See y'all in a couple weeks.
Brenda, she's leaving people behind. She's like, I'm done.
Hungry.
Yeah. There is some food in the back, but that's okay. I understand.
What's in the back?
Things that are not healthy.
I don't care about
Judge,
Yes.
why are you doing that? I'm get this.
Vouchers, 1 or 2 of them maybe past the deadline. They
Oh,
said
just
these-
write a letter saying, just do an attachment why, the reason why. You can just put a letter in there.
Can I do a stick? I'll do that.
Yeah, just write it on it. Do you need a sheet of paper? Yeah.
For the original.
All right, we're back on the record in 2022 CR 8643, State of Texas versus Dwight Basson.
And Judge, what I just handed you are the old copies.
Okay.
We redid all the paperwork.
Okay, so this is old copies?
Yes, sir.
Okay.
I can talk long as I want to now, right, sir?
No.
No, I'm also.
All right. We're back on the record. State, are you proceeding on count 1 or count 2?
Count 2, Your Honor.
Any objections?
No objections.
All right, so it's the court's understanding that the only thing has changed about the plea paperwork is the actual plea agreement. Is that correct?
Yes, sir.
All right,
And that we were proceeding on count 3.
all right.
That is correct.
All right, then the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. And Mr. Batson, according to the plea bargain agreement, you're proceeding on count 2. Your punishment is to be assessed at 2 years in the prison. There are no applications. The state will be taking in consideration 687-856, and there's $57 restitution to SAPD for drug testing. Did you understand that to be the plea?
Yes,
Defense, is that the plea?
Yes, it is.
State, is that the plea?
Yes, sir.
And what is your plea to count to?
The crime.
All right. All right, state, are you offering the previous admitted waiver and consent to stipulation of testimony and stipulations?
Yes, sir.
And Mr. Batson, did you sign that document and review it with your attorney?
Yes.
All right. Then the court, as previously stated, is accepting states exhibits 1 and attachments into evidence. The court is finding there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, we are, Your Honor.
All right, Mr. Batson, the court will follow your plea bargaining agreement. The court will sentence you to 2 years in the prison. Give you credit for any time served. Take in consideration 687-856, and the court has signed that dismissal. There's $57 restitution to SAPD. And give you credit for any time served. Is there anything else with regards to sentencing?
There's nothing else, Your Honor.
Mr. Bassett, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, Mr. Batson, also, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you're questioning what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. We can go off the record. Mr. Benson, you're gonna have to start doing better. Otherwise, you're gonna be in and out of prison, in and out of jail. Don't be the grandpa at the jail, okay?
I won't.
All right, good luck to you.
Hey, God bless you.
All right. All right, so everybody, we are going to be gone for the week. Enjoying Thanksgiving and I would say Friendsgiving. Can we not have, we're gonna have a break. Everybody needs a vacation.
Everybody needs vacation.
Because
We don't all get it, but everybody needs one.
yeah, because you'll be rejuvenated, and re-energized.